Good morning. My name is Bruce Hamilton. I am the acting chairman of the Defense Nuclear Facilities Safety Board. I will preside over this morning's public hearing. I now call this hearing into order. I would like to introduce my colleagues on the board. 2 seats to my right is Board Member Jesse Roberson. To my immediate right is Board Member Joyce Connery, and to my left is Board Member Daniel Santos. We 4 constitute the board. The board's acting general counsel, Ms. Casey Blaine, is seated 2 seats to my far right. Several leaders and members of the board's staff who are closely involved with the oversight of the Department of Energy's defense nuclear facilities are also here. And I'd like to recognize the Honorable Jack Crawford. Oh, there you are right there, Mr. Crawford, right up front, who was one of the original board members. So welcome, Mr. Crawford. Nice to see you. The goal for this hearing is to gather information regarding the objectives of the department's Departmental Order 140.1 interface with the Defense Nuclear Facilities Safety Board, the board's access to information, facilities, and personnel, and potential impacts to the board's resident inspector program. The board's enabling legislation contained within the Atomic Energy Act, as amended, defines this agency's authorities, responsibilities, functions, and organizational structure. The enabling legislation assigns responsibilities to the Secretary of Energy in his role as the owner and regulator of the department's complex of sites and facilities regarding cooperation with the board and providing the board with, and I quote, ready access to such facilities, personnel, and information as the board considers necessary to carry out its responsibilities, unquote. The order that is the topic of today's hearing is now the primary vehicle that the Department of Energy uses to implement the Secretary's responsibilities for cooperation with the board. Prior to May of 2018, the department implemented its interface with the board through a DOE manual, a lower-level department directive that was developed through close cooperation between our 2 agencies. The new order did not receive that same level of close cooperation during development. Because of fundamental changes introduced in the order, the board voted to hold this public hearing to discuss those changes with department's leadership. In the first session, the Deputy Secretary of Energy will describe the department's position on interface between the department and the board. In the second session, the board will hear testimony regarding changes contained in the order, including access to information, facilities, and personnel, and potential impacts to the board's resident inspector program. In the third session, members of the public may provide comment. The board announced this morning's hearing on July 19th on its public website and subsequently posted a notice in the Federal Register on August 10th, 2018. To ensure accurate and timely information, this hearing is being video streamed live, as well as recorded through video recording and a verbatim transcript. The transcript, associated documents, public notice, and video recording will be available for viewing on our public website. The board will make the video recording available for at least 60 days. Per the board's practice and as stated in the agenda, we will welcome comments from interested members of the public at approximately 11:30. A list of those speakers who have contacted us is posted at the entrance to this room. In general, we have listed the speakers in the order in which they contacted us, or, if possible, when they wish to speak. I will call the speakers in this order and ask that each speaker states his name or her name and affiliation, if any, at the beginning of that section. Members of the public who wish to provide comments but did not have the opportunity to notify us ahead of time may indicate their desire to comment on a sign-up sheet on the table at the entrance to this room. They will speak in the order in which they sign up, following those who registered ahead of time. To give everyone wishing to make a presentation an equal opportunity, speakers will kindly limit their comments to 5 minutes, and I'm going to be pretty rigorous about that. Information should be limited to comments, technical information, or data concerning the subjects of this public hearing. The board members may question anyone providing comments. The record of this hearing will remain open until September 28th, 2018. Until that date, members of the public, including those observing today's hearing live via video streaming, may submit a written statement to the board to be included in the record. Contact information for submitting a statement is on our public website. The board reserves the right to regulate the course of this hearing, to recess, reconvene, postpone, or adjourn this proceeding, and to otherwise exercise our authority under the Atomic Energy Act of 1954 as amended. This concludes my opening remarks as the acting chairman. I would now like to offer the following personal remark as a board member. On May 24th, by a vote of 3-1, the board approved holding this hearing. Mine was the dissenting vote. In the following weeks, as I had more time to examine the issues, I concluded that I was wrong. I now believe this hearing is extremely important and timely, and were the vote to be held again, I would wholly endorse it. I want to thank Board Member Santos for proposing to hold this hearing, as well as Board Members Roberson and Connery, who carried the motion when I was not yet awakened to their wisdom. I will now turn to my fellow board members for their opening remarks. Ms. Roberson.
I have no opening comments at this time, Mr. Chairman.
Mr. Santos.
Thank you. Acting Chairman Hamilton, fellow board members, Mr. Brulette, Mr. Crawford, and other distinguished guests, stakeholders, and members of the public today in attendance or following today's hearing online. For the board to remain effective, careful attention must be exercised and a high level of understanding, transparency, and stakeholder engagement must be achieved when changes to the role of independent oversight is being contemplated or implemented, whether through a Department of Energy order or by any other means. It is important that we as a board thoroughly assess the impact of any external factors in our ability to perform our mission. The board has a very important role, and I take very seriously the trust placed in us. We provide confidence and transparency to the American people through our independent safety oversight that the elements of the Department of Energy execute the mission safely and that they do not become complacent in their responsibilities to protect the American people against undue risk from radiation in the activities performed at the Department of Energy Defense nuclear facilities. The board provides unique value in that we can zero in and focus on safety without distractions. A strong board can help identify when key safety issues are being displaced and bring them to the attention of the Secretary of Energy and the public in a timely manner. Last fall, following the issuance of the Deputy Secretary of Energy memo dated October 13, 2017, titled Relationships with the Defense Nuclear Facilities Safety Board, we requested that the Department of Energy brief us on changes they plan to make to the interface with the board. My understanding coming out of that briefing, which was held here at headquarters on October 26, 2017, was that changes were going to be primarily focused on clarifying the roles, responsibilities, and lines of accountability of Department of Energy internal elements, and that no changes will affect the relationship with the board or require any significant adjustment on the part of the board. However, on May 14, 2018, the Department of Energy approved DOE Order 140.1. I was surprised to learn that it contained many changes that affected the relationship with the board, that it challenged the authorities contained in the board's enabling statute, and that it significantly altered the role of independent safety oversight without an obvious and commensurate improvement to safety. Therefore, on May 24, 2018, the board approved my proposal to conduct today's hearings so we can finally start a transparent dialogue. We should use the information obtained during this series of hearings to get a better understanding of the impact this new order may have on the board's ability to execute its mission and how its implementation by DOE elements may generate information gaps that should be addressed by both agencies before they impact safety. I appreciate and I'm encouraged by today's participation by the Department of Energy, and I remain optimistic that we will continue our strong and productive relationship for the benefit of the American people. This concludes my opening statement. Thank you.
Thank you, Mr. Santos. Ms. Connery?
Thank you, Mr. Hamilton. I want to thank the Deputy Secretary for taking his time to come talk to us today. We have many questions with regards to this order and the department's intent, the expectations for the execution of this order, and ultimately the impact that the full implementation of this order will have on nuclear safety. I don't want to take up too much time now, but I will outline the questions that I would like to have answered during the hearing. First, I'd like to know what problem this order solves. After 30 years of interaction with the board, the department has issued an order that doesn't simply codify the status quo of the interactions between the board and the department, but changes the interactions significantly and seems to endeavor to limit the board's access and authorities at defense nuclear facilities. Therefore, my first basic question is why? What problem is the order designed to solve? Secondly, the order is very specific in areas as to execution of the order in the field. In fact, it's accompanied by a desk reference that's 58 pages long. I'd note we only have about 65 technical staff members, so that's almost a page per person. It seems a little bit overkill. Therefore, my second question has to do with any changes in expectations in the department's view as to how we do business. How do you envision we will do business differently than we have done to date? And finally, I want to understand the department's philosophy on safety. We see a number of trends where the department has been making changes in safety strategy, such as in 10 CFR 830, the Federal Rule on Nuclear Safety, which is in rulemaking right now, and some of its associated standards. There seems to be a connection between some of the elements of the Interface Order 140.1 and DOE's own efforts to have a graded approach to nuclear safety, and I would like to understand more about the department's overall intentions when it comes to nuclear safety. With that, I look forward to your remarks.
Thank you, Ms. Connery. Our first speaker this morning is the Deputy Secretary of Energy, the Honorable Dan Brouillette. Mr. Brouillette, welcome to our public hearing. We appreciate your joining us today to discuss a topic that is fundamental to our relationships. The floor is yours, sir.
Thank you, Mr. Chairman. And on behalf of the Secretary of Energy, I welcome the opportunity to provide an opening statement. Today's public hearing on the department's interface with the DNFSB. Thank you, sir, for that opportunity, and thank you to each one of the board members for the opportunity to be with you today. Since becoming the Deputy Secretary of Energy, I've had the pleasure of meeting with a number of the board members individually and the board staff. And as you recall, I also visited with board members and the staff in November of 2017 following the issuance of my October 2017 memorandum addressing the department's relationship with the DNFSB, which provides my expectations for how the department will interact with the board and its staff. As I stated last November, and which still holds true today, although the board and the department are independent agencies, the Secretary and I believe that we mutually serve beneficial and essential functions in that the board's independent analysis, advice, and recommendations are vital to DOE ensuring adequate protection of public health and safety of the department's defense nuclear facilities and its operations. We have certainly benefited from your technical expertise, your insights, and your recommendations for many, many years. However, we also understand that when it comes to the safe operations of DOE sites and facilities, the buck stops squarely at our door, and we take full responsibility for that safety, for which Congress and the public holds us accountable, and rightfully so. To that end, we reaffirm our commitment to carry out our mission as a federal department in a safe, secure, and environmentally responsible way. We reaffirm our dedication to providing reasonable assurance of adequate protection to public health and safety. We reaffirm our dedication to protecting the health and safety of our workers, and we reaffirm our determination to accept full responsibility for any and all outcomes of our efforts. Clearly, the board provides valuable insight and advice, but ultimately we at DOE cannot abdicate our own responsibility to manage the risks associated with our facilities and operations in an appropriate and conscientious fashion. DOE line management must be held accountable, and we must have clear roles and responsibilities to ensure that this is the case. These are guiding principles ingrained in how we do work safely. Unfortunately, however, DOE has in the past, through action and inaction, blurred the distinction between the responsibility associated with our ownership of the nuclear complex and the roles of external advisors, including the DNFSB. As a result, and as part of the department's regulatory reform initiative, we've converted an outdated 17-year-old interface manual into a DOE order to reestablish clear lines of responsibility and reinforce our respective roles. DOE as the owner and regulator, and DNFSB as the independent agency providing advice, analysis, and recommendations to assist the department in overseeing our defense nuclear facilities. The DOE order, which the department issued in May of this year, is consistent with governing legislation and does not hinder cooperation with the DNFSB or prevent the DNFSB from providing independent analysis, advice, and recommendations to either the Secretary or others in the department to ensure that we have adequate protection of public health and safety. Since the issuance of the order, we have heard concerns from board members, your staff, and from some congressional staff on what they perceive to be the order's view of the board's jurisdiction. I'd like to address each of those major concerns now. Regarding adequate protection of public health and safety, this is our primary point of interface and should be the focus of our interactions. DOE federal and contractor employees are specially and particularly trained to execute their work in and around the hazards posed by our mission. Their safety is the focus of our training programs and multiple requirements established by governing directives, standards, and procedures. While we value your advice on these matters, and we truly do, this should never detract from our shared focus on protecting public health and safety. Regarding activities involving transportation of nuclear materials, it is our view that the transportation activities for nuclear explosives and for nuclear materials outside DOE facilities are subject to other governing authorities. We agree that your oversight of movements of nuclear explosive and materials within the boundaries of defense nuclear facilities is wholly appropriate. On the issue of access to draft or pre-decisional information, we do reserve the right to control information in the pre-decisional phase. It is an ineffective use of our resources to pursue interim staff positions that ultimately may not be relevant, interesting though they may be. Further, it is necessary for us to work through an internal deliberative process to develop our own decisions prior to sharing them with others. This will ensure that our subject matter experts can freely offer ideas and conceptual solutions, as well as ensuring our accountability and ownership of the resulting decision. We will consider and share this information on a case-by-case basis if we believe the information is mature enough to make the interaction valuable. Finally, concerning oversight of hazard Category 3 defense nuclear facilities, we note that in accordance with the definition of hazard Category 3, these facilities do not pose a risk to the public. While we welcome your review and comment to help ensure that these facilities are properly categorized, as stated earlier, this interaction should not detract from our focus on facilities with higher hazard categorization, which could pose a risk to public health and safety and should be our joint focus. However, it is important to note that even prior to the development and issuance of the interface order, these very issues remained a matter of discussion between the Department and the DNFSB in the context of governing legislation and not any department directive. Looking to the future, here are some of the things that the Secretary and I are committed to carrying out within our department. We will perform our role as facility owner, operator, and regulator, as well as steward for the taxpayer in safely achieving the missions the law mandates the department to pursue. We will cooperate closely with the DNFSB and provide complete access to the information that you need to carry out the board's mission consistent with your legislative mandate. We will proactively engage with the DNFSB so that we fully understand the bases and underlying analysis behind its advice or its draft recommendations, including the safety benefits it sees for departmental operations at the department's nuclear facilities. We will formulate consolidated DOE positions on policy to include directives and standards prior to the board's staff engagement so that we can ultimately speak with one consistent voice. And we will reinforce with DOE line managers the expectation that they will make sound technical decisions, drawing upon all reasonably available information, including the advice and observations from the DNFSB. We believe that implementing these pledges, consistent with the DOE order and the board's jurisdictional mission, will uniformly complement the board's advisory mission and the department's safety management responsibility for its defense nuclear facilities. Mr. Chairman, members of the board, I want to thank you again for inviting me here this morning. I look forward to the comments and the conclusion of this hearing, and I look forward to our future engagements.
Thank you, Mr. Brulette. We appreciate your taking the time to join us here today. In order to allow Mr. Brulette to depart, we will take a 10-minute recess, and we will adjourn, or we will reconvene by this clock at 35 minutes after the hour. Thank you. At this time, I would like to reconvene our hearing and continue by inviting our panel of witnesses for Section 2, including Mr. Matt Mowry, Associate Undersecretary for Environmental Health, Safety, and Security, and Mr. Ike White, Chief of Staff and Associate Principal Deputy Administrator of the NNSA, and Mr. Chris Rossetti, our Technical Director here at the Board. Mr. Mowry and White are here on behalf of the Undersecretary of Energy and the Undersecretary for Nuclear Security, respectively. Does anyone on the panel wish to submit a written statement? Not at this time. Okay. The board will ask questions of the panel members. Other panelists may seek recognition by me to supplement any answer as necessary. If any panelist would like to take a question for the record, the response will be entered into the record at a later time. We will begin with questions from board members, and I will start with the first question. Mr. Rossetti, there have been prior attempts to issue an interface order to replace the departmental interface manual that were undertaken in the past decade. Could you briefly describe what these efforts were to your knowledge?
Yes, sir. On two separate occasions, the department attempted to revise its Manual 140, the directive that preceded the recently approved Order 140.1. In 2007, the department embarked on what was called the Office of Health, Safety, and Security Directives Review, or HSS Directives Review. Manual 140.1 was part of Phase 2 of this effort. In July 2009, the board staff members reviewed a draft of the department's draft Order 140.1. The HSS Directives Review was subsumed by the department's 2010 Safety and Security Reform. The Office of Health, Safety, and Security also led the 2010 Safety and Security Reform. Again, the staff reviewed a draft, but those drafts were never finalized and issued. Consequently, the interface manual continued to govern the department's interface with the board until May 2018. For the 2011 effort, the department's justification memo noted that the conversion was called for by the departmental direction requiring conversion of manuals to orders during their normal review cycle. The justification memo for the 2011 effort noted that the major changes were to provide more concise goals and requirements and to condense the sections on interactions between the department and the board. No other explicit changes beyond converting and streamlining the content of the interface manual were identified in the justification memo. The board staff review of the previous draft orders indicate that the general intent of the 2011 justification memo to convert and streamline the interface manual was carried out in the previous drafts from 2009 to 2011. The previous drafts did not include significant changes in interface expectation, changes to the scope of the board's oversight, or changes to access to information, personnel, or facilities. In a memo dated September 25, 2017, and in response to direction from the Deputy Secretary, the Department's Office of Management requested an evaluation of the interface manual. In May 2018, the new interface order was issued with major changes from the interface manual. I request Exhibit 5 to be entered into the record, which summarizes the staff's view of the major changes. These changes will be discussed during the course of the hearing and include the department's new definition of public health and safety to include only individuals beyond the site boundaries, the department's new restriction on access to information for hazard category 3 and radiological defense nuclear facilities, the department's new restrictions on access to deliberative documents, pre-decisional documents, or deliberative meetings, the department's new requirements for contractors to refer all requests for information or access related to defense nuclear facilities to a departmental site liaison for determinations regarding response and to only respond when formally tasked by the departmental site liaison.
Thank you, Mr. Rossetti. Mr. Mowry, could you discuss for us the goals, objectives, and intended improvements that drove the need for the changes from the prior interface manual to this order?
Thank you, Mr. Chairman. Mr. Chairman, members of the board, it's a great honor to be here to represent the Undersecretary, so thank you for inviting me. I don't think I can add a whole lot to what the Deputy Secretary has already read, but we are blessed with having Captain Crawford here, one of the original board members, and there are three general themes, I think, that he always emphasized when I was a member of the Defense Board member staff. As you well know, I was with the staff for about 18 years before I went over to the Department of Energy, first in the Office of Environmental Management as a Deputy Assistant Secretary, and now in my current position. And one of the major themes that he always emphasized, that I've always carried with me, is clear roles and responsibilities and line management's responsibility for safety, very consistent with our guiding principles for integrated safety management. The second one that we always talked about was the need to institutionalize processes. And that was always a common complaint whenever we were reviewing department programs and found them devoid of process. So the order also puts a very formal process in place for how we deal with board recommendations, especially the new ones related to draft recommendations and requests for documentation, et cetera. And then finally, probably one of the most significant themes that he always emphasized was that the department needed to be a demanding customer with their contractors. So it's very important, as you read through the order, that we require the Defense Board, or we ask the Defense Board to interface with the Department of Energy, because the contractors work for the Department of Energy. And we would be the ones that need to be aware of what work is going on, what they're providing to the Defense Board, discussions that are going on. So those are some of the themes, I think, that are very important that are carried into this order to make it a more structured order than the existing manual, which, by the way, was 17 years old, no longer compliant with the board statute, and really needed to be updated. Thank you.
Let me follow Let me follow, and thank you, Mr. Maurer. Let me follow on with the second part here. The Deputy Secretary issued a department-wide memorandum October 13th, 2017, which I will request be entered into the record as Exhibit 4. The memorandum discussed his intention to continue a strong and productive relationship with the board, which is great, but how does this order do that?
Well, I personally, I mean, and you'll hear from my colleague, Mr. White, when he talks about NNSA and their interactions with the Defense Board. But I think all it does is just structures many of the existing programs that we have in place with the Defense Board. Requests for documentation, it still follows the same process, requesting of a request for information, so on and so forth. I don't see it as a significant change in how we are going to interact with the Defense Board. And I think it's important as we move through in this discussions and you continue with your questioning that Mr. White has the opportunity to talk to you about how, at least on the NNSA side, they plan to interact at the site level with your site resident inspectors.
Well, let me ask Mr. White right now then, do you have anything to add to that you could share with us right now?
No, I mean,
Specifically how this improves the relationship between the board and the department?
Well, I mean, my perspective is the order itself is intended to continue our relationship, right? It certainly is not intended to harm that relationship. The primary points from my point of view are mostly about roles and responsibilities on our side and about ensuring that our folks have ownership and accountability for decisions they make. But it's certainly not intended to have a negative impact on the relationship between us and the Defense Board.
Thank you. Mr. Santos, please.
Thank you, Acting Chairman. Mr. Maury, we understand that the development of this order followed the integrated project team process. I have a series of questions regarding the integrated project team for this Order 140.1. I ask you to please provide simple yes or no answers in order to save some time. First question, did the integrated project team include any member from the Defense Nuclear Facilities Safety Board?
No, that did not.
Okay. Second,
Let me just add one thing, and with your permission, Mr. Chairman, I would like to submit a copy of DOE Order 251.1, which contains the process for the integrated
granted.
project team. Thank you.
so
We'll mark that as DOE Exhibit 1.
Thank you.
did the integrated project team include any member from local governments from the communities that live near defense nuclear facilities?
Not that I'm aware of.
Did the integrated project team include any member from worker unions?
Not that I'm aware of.
Did the integrated project team include any member from the public?
Not that I'm aware of, no.
Did the integrated project team include any member from contractor organizations that operate defense nuclear facilities that are subject to DNFSB oversight?
Not that I'm aware of.
Okay.
Mr. Santos, I think it's important to realize that we were creating an internal document for the Department of Energy that lays out roles and responsibilities for the department, and as such, it was considered an inherently governmental process, which was why many of those people that you mentioned are not on the team and are not on our teams whenever we develop DOE orders.
I think, Mr. Robertson, you want to follow up or you want to, go ahead.
I was going to suggest that you take for the record to confirm who was on the team in response to
That would be
that last
fine.
question.
We'll provide the list
That's
of all the
different.
members of the IPT.
Thank you.
Yeah, I was going to go to tab O in our booklets. We have here a memo dated September 25th, 2017, that I would like to submit for the record. Mr. Chairman.
So granted, please read the subject and the subject line for the record.
Subject line, request to conduct evaluation of DOE Manual 140.1, interface with the Defense Nuclear Facility Safety Board and provide a proposed change to the manual into an order. Okay. I would like to note that on that memo, there's several members that are from contractor organizations, and I would like to ask Mr. Murray to reconfirm the participation, and if you can please provide for the record the recommendations the contractor organizations gave to the Department of Energy regarding the content of Order 140.1.
It'll be submitted for the record with the chairman's permission.
So granted.
Thank you.
Chair recognizes Ms. Connery.
So along those lines, Mr. Maury, you submitted for the record DOE Order 251.1D. That order requires, and I quote, "transmission of draft directives, invoked standards, and other relevant approved documents through the DOE Department representation to Defense Nuclear Facility Safety Board for directives of interest to the board," end quote. Was the draft interface order formally transmitted to the board as required? If not formally transmitted as required, why wasn't it formally transmitted?
I believe it was provided to the Defense Board. The details of that I'll have provided for the record.
I do not believe that it was provided formally. Mr. Chairman, would you care to comment?
To my knowledge, the only exchange between the board and the Department of Energy was an email exchange that I had with the administrator of the NNSA, which clearly noted, and I will submit this for the record, this email, that is dated May 7th, and I want to read the second sentence here, second, third sentences, just to be clear. "The informal suggestions for consideration that I've collected below do not represent an official act or viewpoint of the board. The board reserves the right to comment on this order either before or after its issuance." So the short version of the answer, as I know it, is that there was never any formal exchange. There was only this one email that I sent to Administrator Gordon Haggerty that was warning her that there were things that we didn't think were appropriate in this order. That's my only knowledge. Do you know of anything else?
I do not, but I'll confirm with the IPT and the Directors Review Board and then provide that response for the record.
Thank you.
So along those lines, the IPT, the Integrated Project Team process, seems to bypass the board in terms of having us look at any input or development to directives revisions. In particular, obviously, 140.1, which is the interface document, but also we've noticed the same thing on 10 CFR 830, which is the federal rule on nuclear safety management, 420.1, the order on facility safety. So I want to understand if it's the department's intent to limit the board's access and input on development of directives.
No, as noted in the board's own policy statement on their review of directives, you're allowed to look at directives whenever requested. Whenever you request to look at those directives, the intent of the IPT is not to restrict the board from looking at them. Going back to the Deputy Secretary's statement, his only request is that we be allowed to provide a consolidated position so that we are speaking with one voice as a department.
So after the department's concluded its work, has a document that it's ready to submit, then after the decision has been made, you'll submit it to the board only upon request for comment? Is that how I understand that?
If you request a document consistent with our request for information and consistent with the process that we've been following for the last 20 years, that's the way the document will be provided to the board.
So your staff is not required or instructed to provide any documents to the board that may be of interest to the board unless the board requests it and knows that such a document is under review?
Well, since your policy statement was issued, we have provided some documents that the board has elected not to review, and I can provide that information for the record. I don't have it off the top of my head. So our position right now is that if you would like to review the document, please request that document and we will provide it. There is no intent to prevent you from seeing that document. As far as 830 goes, we have a letter from the chairman that says that you will comment on 830 as part of our notice of public rulemaking process. And We just recently had that notice of public rulemaking released. The document is out for public comment, and we are looking forward to having the board's comments on their position on the rule.
I would note that we submitted that letter after the document was in its final form, ready to go to the Federal Register. That's when we sent the letter saying that we would comment during the public comment process.
I'm going to refrain from talking about 10 CFR 830 since this is not a public meeting on 830. If we want to have a subsequent discussion on 830, I'd be happy to do that.
I look forward to that. So one last question along this line, Mr. Mowry. The central technical authorities who have responsibility for nuclear safety execution in the field, and you quoted Captain Crawford specifically on that matter, they normally review documents that potentially impact nuclear safety. Can you discuss why the central technical authorities, whether or not they were involved in the development of this order, and if they weren't, why not?
I believe all our significant program offices with central technical authorities were engaged in the development of the new order. I can have Mr. White confirm on the NNSA side whether their central technical authority was engaged, but I believe they were all a part of this process.
I'm happy to respond if you'd like. For NNSA, our Central Technical Authorities Office led our participation in the order revision.
Thank you.
This question will be addressed to both of you, Mr. Mowry first and then to Mr. White. The board's legislation states that the Secretary will provide, and I quote, ready access to such facilities, personnel, and information as the board considers necessary to carry out its responsibilities, end quote. This access was specifically afforded in the previous DOE interface manual. However, the new order does not include this language. Instead, it says, quote, provide the DNFSB with ready access to such facilities, personnel, and information as necessary to carry out its statutory responsibilities, end quote. In other words, the order deletes the statutory phrase, quote, as the board considers necessary, unquote. Mr. Mowry, could you discuss the basis for not including that statutory language in the new order? Specifically, why you deleted the phrase as the board considers necessary. And Mr. White, I'll ask you the same question.
As I'm reading the statute under responsibilities of the Secretary of Energy, it says the Secretary of Energy shall fully cooperate with the board and provide the board with ready access to such facilities, personnel, and information as the board considers necessary to carry out its responsibilities under this subchapter. DOE 140 still allows that to occur. I'm a little confused on why if you could rephrase your question again on exactly what.
Let me be a little bit more specific then. In your order, the access to information phrase ends with to carry out its responsibilities. And you've deleted the phrase as the board considers necessary. So in other words, the statute very specifically gives the authority to decide what is necessary to the board. The board has the authority to decide. That language in the order has been diluted so that it says simply statutory responsibilities. Why did you dilute that phrase?
Well, the statute also allows the Secretary to deny access to certain information as well. So when we look at the statute for what the Secretary, or look at the order for what the statute, for what the Secretary will provide to the board, cooperate with the Defense Board, provide the Defense Board with ready access to facilities, personnel, information necessary to carry out its statutory authorities to include and provide access to. And the first group is those things that will be provided just carte blanche automatically to the Defense Board. The part that I think you are referring to is where the Secretary may deny access as allowed by the statute. And those areas are subject to discussions, which is occurring even before DOE 140 was published. But the restrictions that the Secretary has, as allowed by the statute, the person requesting the information does not need such access in connection with his or her duties. And then the request is for pre-decisional, which the Secretary or Deputy Secretary talked about in his comments. So there are two elements to this piece of information that the board may be requesting. The first piece being that information, readily accessible, completed documents that will be provided to the Defense Board whenever they provide a request for information. No change to that. That's as determined by the Defense Board. The second piece is the pre-decisional piece that you may get some pushback and discussion to understand exactly how it is going to be fulfilling the board's mission.
Mr. White, do you have anything to add? If not, that's okay. Just
Well,
give you a chance to talk.
a couple of things. One is, I'm not sure the statutory distinction, the wording in the order versus the what we ended up with in terms of the new revision to the order. But I would point out that from NNSA's perspective, I led a training session for our field office managers, for our plants, for our laboratories, for our points of contact, to make sure that it was clear to them that for NNSA, that we intended to continue to provide the board and its staff with ready access to all of our nuclear facilities. So, the current unescorted access that your resident inspectors have at all of our sites is to continue just as it has. This order is no change in that regard. We will continue to respond to requests from you for information related to all of our defense nuclear facilities, just as we have in the past. This order for us does not change that. The discussion we had earlier on draft and deliberative information, that discussion is actually in the old order as well as in the new order. And that's not really for us, it's an emphasis point for accountability and responsibility for safety, but it's not a change historically in the way we've operated. We have, the first 13 years I spent on the board staff, and 4 years of that as a resident inspector, we routinely had conversations with the department on access to draft and pre-deliberative information. And I don't expect I expected those under the previous order. I expect those conversations to occur under the new order. So I don't see a change.
Thank you, Mr. White. I am less concerned with that kind of gray area about internal DOE deliberations. I think reasonable people could agree to disagree on how you carve that up. I'm not arguing that. But just for the record, my concern is that it appears that by taking out the phrase, "the board considers necessary," there's been a subtle attempt to say that the board doesn't get to decide, when in fact the statutory language specifically says the board considers necessary. That's my point. We don't need to beat it anymore. I do want to ask Mr. Rossetti, do you have any examples since the issuance of the order that the staff has encountered any difficulty assessing information?
Mr. Chairman, the department's still implementing the new order, which includes updating contracts for its management and operating contractors. Although the order is not fully implemented, the staff has observed increased difficulties in obtaining information from the department. For several documents, we have observed protracted response times as the management and operating contractors consider their responsibilities to provide the requested information based on the language in the new order. In most cases, the department personnel eventually overturn the contractor's decisions. However, let me provide you with 4 specific examples where the department has not provided information or access that the staff requested. I request Exhibit 6 be entered into the record. As noted in Exhibit 6, the staff has encountered difficulties with access to documents needed to determine the veracity of a worker complaint related to safety at Los Alamos National Laboratory, documents related to safety challenges of transitioning to shift work at the Los Alamos Plutonium Facility, deliberations during nuclear explosive safety studies at the Pantex plant, and technical basis documents from Los Alamos National Laboratory related to the redefinition of high explosive violent reaction.
Thank you, Mr. Rossetti. The chair recognizes Board Member Roberson.
Thank you, Mr. Chairman, and thank the panel. I haven't had the opportunity to do that yet. First of all, and I appreciate very much the Deputy Secretary as well as the three of you participating in this hearing. A couple of things I want to say leading into the line of questioning is to emphasize, I don't want there to be any confusion, the board understands line accountability, and it understands the department is responsible for its operations. The board hopes the department doesn't see the board as competitive but complementary to ensuring safety. That's what our mission requires, and that's how we're focused. So the line of questions we're asking is not to challenge your authority in executing accountability, but to try to understand your intended impact to oversight of those functions and safety. So my first question is, the order uses the term public health and safety, which is a key term in our legislation under the Atomic Energy Act. In particular, the term applies for board recommendations, and I quote, "As the board determines are necessary to ensure adequate protection of public health and safety," end quote. However, DOE included a new definition in the order of public health and safety, and I quote, "Health and safety of individuals located beyond the site boundaries of DOE sites with DOE defense nuclear facilities," end quote. I'm not aware that our legislation or other parts of the Atomic Energy Act refers to the site boundary as the demarcation for defining public health and safety. So my first question, Mr. Mowry, is can you help us understand the origin of this definition for public health and safety as it is the concept is incorporated in your order?
Well, clearly you don't have any attorneys up here, but I will do my best to answer your question, Ms. Roberson. We have never defined co-located workers as members of the public. 10 CFR 835 on occupational radiation protection that was published in 1993 defines a member of the public as an individual who is not a general employee. We treat the public differently on the legal limits for radiation exposure, but we also train our co-located workers, as I mentioned earlier, on the risk they are exposed to and emergency response procedures. This definition is also consistent with the definition in the DNFSB Technical Report 20 on co-located workers, written by former board member Dr. Kautz, with assistance from Mr. DeNuno, that defines co-located workers as individuals who are employees of DOE or of one of DOE's operating contractors or mission-related subcontractors at the nuclear site where the facility in question is located, but who spends little, if any, of their time in the facility. That doesn't mean because we don't categorize them as public that we don't protect them. We have a robust series of enforceable rules, directives, standards framed around integrated safety management, including 10 CFR 835 I just mentioned, 10 CFR 851 on worker health and safety programs, 10 CFR 830 on nuclear safety, just to name a few that we use to ensure the protection of the co-located workers that are inside the fence boundary.
So thank you for that. Once again, the board is not challenging how the department chooses to execute its line authority, but are really focused on how the language in the order affects the ability to do independent oversight. And I think on Tech 20, there may be some disagreement as to what it concludes and what information it presents, but I think we're going to talk about that later, so I don't need to follow up on it. I have one last question on this topic. Is it the Secretary of Energy's position that facility workers and co-located workers, and indeed anyone present at a defense nuclear facility site, are excluded from the adequate protection standard of the Atomic Energy Act?
Do you mind if I answer that one?
I would be honored.
Thank you, Jesse, appreciate that. The department is committed to adequate protection of all of its workforce, all of the folks who are at our sites, and all of the members of the public.
Okay, Mr. White, you didn't actually answer that question.
What was the
You-
question?
You definitely added fruit to the conversation, but.
I mean, we're definitely committed to adequate protection of our workforce. We're committed to adequate protection of all of the folks located on our sites, and we are committed to adequate protection of the public.
That answers the question. Thank you very
Yes.
much.
Ms. Roberson, I'd like to add one clarifying question to your line of inquiry, if I may. I heard all your references to previous documents, Tech 20, Code of Federal Regulations. My question, the thing that I did not hear was, is there anything in the Atomic Energy Act that defines the public health and safety as being restricted to outside the site boundary? And I think that can be a yes or no question.
I think it only refers to whether they are a employee of the organization or are not an employee of the organization.
Okay? I'm not sure that that helps me, but I'll stop there.
Thank you, Mr. Chairman.
New topic, we'd like to talk about hazard categories. The order states that it does not apply to DOE nuclear hazard category 3 or below hazard category 3 facilities. Now, as I read the order, and it's a little bit confusing to me when it says excluded, because a clear reading of that order would say that those are outside this order, but I think the way that the order is written is that the Defense Nuclear Facilities Safety Board is excluded from DOE nuclear hazard category 3 and below hazard category 3 facilities. I note that the hazard category definition of the defense nuclear facilities is not addressed in the Atomic Energy Act. It is also a department construct. So, Mr. Mary, could you explain to me the basis for limiting board oversight to only hazard category 1 and 2 nuclear facilities? I'm specifically looking for the statutory basis for that.
Well, the hazard category taxonomy is a risk-based taxonomy, so it allows us to prioritize our resources on the highest risk activities, which in this case are hazard category 2 and hazard category 1 facilities, as you so mentioned. That does not mean that, well, let me back up one step and say that, restriction of the board is not in the order. This order is for defining the roles and responsibilities of DOE and its contractors. So saying that it's restricting the defense board is not. If that's confusing, I apologize. But as far as access to hazard category 3 facilities, as Mr. White talked about earlier, that you still have access to hazard category 3 facilities. You still have information on categorization of those hazard category 3 facilities. If there's any question that we categorize them correctly or not, you have access to that information. If you request documents on hazard category 3 facilities, if they're available, they'll be readily provided. What the board chooses to do with those documents is up to the board. But we are always open as a learning organization to any comments that you may have, any concerns you may have, any safety issues that you may have relative to those hazard category 3 facilities.
Thank you. I want to be really clear because let's take a look at the order. Order 140.1, paragraph 3, Charlie. Exemptions and exceptions. Equivalencies and exceptions to this order are processed in accordance with some other order, 251.1, current version. And then it lists exemptions. And it lists exemptions that are in the statute. For example, the very first one is the order does not apply to naval reactors programs. That's right in the statute, and I get that. So in other words, I don't, as the board, we don't have jurisdiction over the naval reactors program. Clear as a bell in the statute. But the second one says this order does not apply to DOE nuclear hazard category 3 or below hazard category 3 facilities. And it goes on to talk about how we will be provided access to information that led to the determination that it was a hazard, that it was less than hazard category 2. So does the order, does this exemption mean that I don't have access, my board, my agency does not have access to hazard category 3 and below? Is that what this exemption means?
No, it gets back to our discussion we had earlier about public health and safety. By definition, by our 1027 standard on hazard categorization, hazard category 3 facilities only have localized effect. There is no public health and safety effect associated with hazard category 3 facilities. That is what that terminology is in there for. And
Okay.
Mr. White has something that he'd like.
Yeah, I'm gonna let you talk, but let me just close on this, because I think this is really crucial that we understand each other. You, the Department of Energy, are defining a construct, hazard categories. That's not in the Atomic Energy Act. The Atomic Energy Act doesn't speak to those hazard categories. So you're defining hazard categories, and then you're saying, in these categories, there's no potential detriment to the adequate protection of the public health and safety, so I don't have the right to look at it. So you're making the determination that what I can look at and what I can't. I've got to understand that. Let me.
Sure, no, I
ahead.
understand your question exactly. So if you have some question about that hazard category 3 facility and you think it does have an impact on public health and safety, please look at that facility. Request those documents. Confirm that we have made that characterization correctly. If we have not, and it is a hazard category 2 facility, then we need to elevate the hazard categorization of that facility.
Let Mr. White, I know you wanted to chime in on this.
Well, it's important to understand that in the construct of how these orders are put together, those exemptions apply to department personnel and its contractors relative to a minimum set of requirements. So orders establish a minimum set of things that we are required to do. An exemption simply means that the department's employees and contractors don't necessarily have to do the things in the order if the exemption otherwise would apply. The order does not pertain to what you may or may not choose to do. It doesn't govern the operations of the board or its staff. It doesn't prevent our employees or our contractors from doing anything that they think is in the best interest of the department and of the government, except in cases where it explicitly does that. And certainly when I, like I said earlier, when I trained our folks, I mean, I had a video conference with all of our field office managers, our plant and our laboratory leadership, and all of our POCs who have to implement this order, and I made it very clear to them that exemption and that language was not intended to deny you access to hazard category 3 facilities, nor was it intended to be a reason we would not provide you upon request information associated with the operation of our hazard category 3 facilities. And if you see any evidence of that occurring, please bring that to my attention and I will correct it.
Thank you. So by definition, I note that the radiological laboratory utilities and office building, commonly referred to as the RULAB at Los Alamos, is a hazard category of 3 or below. Do we have access to the RULAB?
If your resident inspector would like unescorted access to RULAB, there's no reason he shouldn't have that access. So if that's not occurring, let me know and I'll
Okay,
take care of that.
so what I'm taking from this, then, is that the department is not trying to restrict our access to Category 3 and below, and if that's the case, I would offer for your consideration that when I read this document and exemptions list that along with things that are statutorily off limits to us, like the Naval Reactors Program or off-site transportation, there's a whole 8 of them here. The safety of atomic weapons, some of those are statutorily off limits to us, and I get it. But that one is not, and yet it's in the same pile. So it's very confusing the way I read it. That's just a statement I wanted to make. I'm going to call on Board Member Santos first, and then Board Member Connery. Mr. Santos.
Thank you, Acting Chairman. I'm very confused. So I have a question. Do you consider that the board and its staff need to even follow your risk-based construct of hazard categorization? Do you feel that's a requirement for the board and its staff to comply with?
We establish no requirements for the board. If you don't want to follow it, then you don't have to follow it.
So we don't even have to entertain a debate on what categorization of a facility it is, whether it's 3, 2, or 1. That's not relevant for the board's independent oversight. Is that correct?
If there is no impact on public health and safety, and you're requesting a significant review at a hazard category 3 facility that's going to take significant resources out of the Department of Energy, I think that's a topic that requires discussion.
So
And we've had those discussions in the past.
Thank you.
The board chair recognizes Ms. Connery.
So, Mr. White, I appreciate the fact that you're out there training your staff to say this doesn't mean that we don't have access to these facilities. That, again, the training seems to contradict what's in the order, so I would suggest that perhaps you align the order with how you're going to implement, if you're saying this implementation is going to be as benign as it seems to be. And Mr. Mowry, what you're suggesting, if I understand it, it took a long time to get there, is that you put forward your categorizations because that's your risk-based assessment as to where you're going to apply your resources. The board can apply its resources wherever it wants, can go into these facilities if they want to, but the department will not entertain, without significant debate, any activities that would cause the contractor to have to provide information to us that they feel is in excess, or that the department feels in excess, or would not necessarily need to respond to either a reporting requirement or a recommendation by the board if you don't feel that it impacts the public health and safety by your definition. Is that my understanding?
I think that's an accurate representation. Thank you.
Mr. Santos.
Thank you, Acting Chairman. I have a question for Mr. Rossetti. If you can pull out some of the examples that you were, thank you, Exhibit 6. In your view, were any of these examples, the difficulty arose due to the DOE's view that none of these issues impact public health and safety, or that they were associated with some other type of hazard categorization? Can you explain some more details of the rationale provided by DOE for providing the difficulty in accessing the information?
So let me repeat
Yes.
the question so I understand it to be able to answer it. So you're asking with these 4 examples in Exhibit 6, if any of them are related to DOE's hazard categorization of the facilities?
That's one, or their view that any of the issues underlying them does not impact public health and safety.
Okay. So let me start with the bottom bullet regarding the technical basis documents. My understanding is the reason that we had trouble accessing that information was because it was pre-decisional or deliberative.
Okay?
The third bullet, deliberations regarding the nuclear explosive safety studies at Pantex was also, again, deliberative. With respect to the second bullet and the first bullet, I don't know the specifics of those document requests, so I will have to take the question for the record as to whether or not those 2 difficulties accessing information were related to the department's view regarding the effect or impact on workers versus public health and safety, sir.
Thank you. If you could take it for the record, I appreciate that. Because one of the things I'm trying to understand is whether, without debate, the department is simply expressing their view that it doesn't impact public health and safety without the board's view of whether it does or not. So, okay.
Mr. Mowry, to kind of finish up on this line of inquiry, the order contains further exemptions and definitions for hazard category 1 and 2 facilities that do not contain safety class controls. Is it the intent of the order to in any way restrict the board's access to only facilities with safety class controls?
No, I think, are you trying to get at the idea of restrictions for criticality safety? Is that your concern?
To some degree, yes.
To a large extent?
There's other examples, but you can use that one.
Well, let me begin with criticality safety. I think we recognize that, one, ensuring appropriate oversight of criticality safety is important. It's a special, unique area. It provides us with, provides the public with a certain degree of understanding and comfort that we are providing the adequate level of protection. We have an annual reporting requirement to the board that we will continue to fulfill in the area of criticality safety. So that information will still be provided to the board. I am not aware of the other facilities that are Category 2 without the safety controls, and I would have to take that as a lookup and provide that to the record.
Thank you, Mr. Mowry. The chair recognizes Board Member Connery.
So I apologize, this is going to have a little bit of a lengthy introduction, but that's mostly for the public edification. The order defines those facilities that impact public health and safety, as we have just been discussing. Based on the exemption 3 and the definitions in the order, those facilities would need to impact individuals beyond the site boundary for them to be relevant. 2, have special nuclear material as defined in the order, which notably does not include tritium. And 3, use safety class controls, as we just discussed. While I do not subscribe to the department's definition of and limits to the board's statutory authority in these areas, I would like to discuss the attempt to separate public safety from worker safety. Safety is an integrated system relying on layers of engineered and administrative controls and practices. These layers of defense often fail in isolated ways, evidenced in low-level events that may impact only the workers prior to a series of failures which could ultimately lead to a release of off-site to the public. To illustrate, I would introduce Exhibits 7 and 13 to the proceedings. This is the Board Technical Report 20, which Mr. Mowry referenced earlier, Protection of Co-located Workers at the Department of Energy's Defense Nuclear Facilities and Sites, issued in 1999, which lays out the case for the interdependence of controls and systems to ensure safety. Catching and correcting failures at the lowest levels can predict and prevent larger-scale problems that could lead to a public release and provides the most effective protection of the public. If I cannot evaluate all the layers of defense in depth to understand where potential weaknesses exist, I cannot make a determination of adequate protection for the public. Mr. Mowry, do you agree that deficiencies identified in a non-safety class control could have potential implications for safety class controls either at the same facility or at another facility on site?
Could you repeat that your last piece?
Do you agree that deficiencies identified in a non-safety class control could have potential implications for safety class controls either at the same facility or at another facility on site?
Well, if we are talking about workers and their response to an accident situation where they are relied on to ensure adequate protection of public health and safety, then yes, that definitely would apply. And I think the board is fully entitled to look at those controls that are necessary to be in place to ensure that protection. If you're asking, can those controls have impact on adjacent facilities, that again is where we are talking about public health and safety versus co-located and worker safety. And the board's or the department's position right now is that we have many controls, many programs in place that ensure that protection of our own employees. And as the Deputy Secretary mentioned in his comments, the buck stops with us on protection of those employees.
Mr. White?
So the direction I gave our folks was fairly clear, which is we'll continue to support the board's staff reviews and assessments at all of our hazard category 2 facilities, with no distinction about whether we're talking about safety class or safety significant controls. In terms of the advice and recommendations you guys provide, as we always have, we'll take into account larger questions of risk management, and we'll discuss those with you. But there's no expected change from our perspective in terms of how we respond to those. I mean, there will always be questions of timing. There was Recently, we worked with Ms. Roberson on timing a review at Pantex, but those have nothing to do with this order or your statutory responsibilities. Those simply have to do with our availability of resources.
So just to be clear, I wasn't necessarily just speaking about a worker that performs a function that a non-safety class control affecting that worker could then implicate a safety class control. I was talking about more of an integrated safety management system in which an erosion of capabilities in a larger facility or the facilities themselves becoming degraded could be lead indicators for something happening at the facilities that would have impact to the public health and safety.
And that's one of the reasons that we will continue to support your staff reviews in all of our HAZCAT 2 facilities.
And like I said, I appreciate the fact that you want to implement that way. My challenge is that that's not what the order says. And when you go away and your successor comes along and they read verbatim what's in the order, then we are going to have a challenge going forward, and the next board or successive boards will not be able to have access to that information, and we could be facing a big challenge at the facilities.
Okay, I mean, I don't read the order that way, but I understand your point.
So my last question is for Mr. Rossetti. Can you discuss the potential implications of restricting the board's oversight role based on the exemptions and definitions as written in the order?
All right, so as you said, safety is an integrated system, and the adequate protection of the public relies on defense in depth and layers. To help answer your question, I request Exhibit 8 be entered into the record. The exhibit represents the staff's analysis of candidate defense nuclear facilities across the complex, broken down by potential restrictions in the interface order. Reading the words in the order, the board's access could be limited to just those facilities with safety class controls, as indicated by the red arrow on the slide, representing a 71% reduction in the number of candidate facilities. Next, I request Exhibit 9 be entered into the record. It further illustrates the impacts of the order's restrictions by site. Specifically, the green bars represent the total number of candidate defense nuclear facilities at a given site. The red bars represent only hazard category 1 and 2 nuclear facilities with safety class controls. You can see a large drop in the number of facilities at most sites. Notably, the waste isolation pilot plant does not have any safety class controls. Therefore, the department could prevent the board oversight at the waste isolation pilot plant. Again, I reiterate what you said. Safety is an integrated system, and the adequate protection of the public relies on defense in depth and layers. Limiting the board's access to just those facilities with safety class controls would prevent the board and the board staff from evaluating those layers.
And just to put a point on it, because as the department has stated several times, they won't necessarily limit our access, but they will limit their response. And our effectiveness is only as good as the department's response to our advice.
For this line of inquiry, the board recognizes Board Member Santos, or the chairman recognizes Board Member Santos.
Thank you, Acting Chairman. I just want to follow up on the last point by Ms. Connery, and I'm a little bit confused. If I pay attention to the answers provided by Mr. White to Ms. Connery, you kept referring to hazards category 2, but in the previous discussions, we were discussing that, no, we will pretty much have access and information to all defense nuclear facilities. So are you trying to limit to hazard cat 2 or not?
So we intend to provide information and facility access related to all of our defense nuclear facilities.
Okay.
The cases where we may push back will relate to in-depth staff reviews at a facility that pull away site resources to look at a specific subject. If that subject appears to have no real significance from a safety perspective, we may do the same thing we've always done with you guys and pick up the phone and call and discuss whether that really is the best use of our resources and yours.
Thanks. So following up on that, you mentioned in-depth or resource commitments. Do you have any criteria, or have you communicated any criteria what will constitute a threshold, or when you feel that the staff request exceeds that threshold and therefore there should be pushback?
No, we've never needed such thresholds in the past, and I think we've worked just fine in working through all of the issues that we've had in the past, and I see that continuing.
So right now there's no guidance. Okay, thank you.
Well, thank you, Mr. Santos. The board recognizes, or the chairman recognizes Ms. Roberson.
Thank you, Mr. Chairman. I didn't choose to raise my hand, but I will say to you, the reason we're asking questions is because we do see impact. And I think that's important to know. We're just not looking at the words, we're assessing what we're actually seeing in the data we're gathering. The board has provided recommendations and other advisory correspondence to the department in areas that focus on safety of workers, such as criticality, safety, radiological protection, work planning and control, conduct of operations, and tritium activities. The department emphasized the word public in its order to make it explicit that the department does not view the role of the worker in ensuring nuclear safety as an essential component of how the department protects public health and safety. So I'd like to start with Mr. Rossetti. Can you summarize for us the board's correspondence in recent years identifying safety issues and any actions taken by DOE in areas that may now be exempted by this order as it relates to worker safety?
The board has identified safety issues and sent the department recommendations, technical reports, and other correspondence in areas that are now exempted by the interface order. I'll share a few examples to illustrate previously identified board safety issues which fall into these areas. I ask that Exhibit 7 be entered into the record. First, with regard to board recommendations, the strongest communication the board can send to the Secretary of Energy. There are at least 13 board recommendations that explicitly discuss worker safety. I note that in none of these cases did the department's response to the recommendations challenge or otherwise question the board's statutory authority regarding worker safety. As an example, recommendation 2012-1 concerned Building 235F at the Savannah River site. In one accident scenario, the calculated unmitigated dose consequences to the co-located worker was 27,000 rem total effective dose. For perspective, the department's directives generally require safety controls for potential worker exposures in excess of 100 rem total effective dose. At the time the board sent the department recommendation 2012-1, the worker population near Building 235F routinely numbered more than 1,000. In response to the board's recommendation 2012-1, the department developed an implementation plan which addressed safety issues and improved worker safety. Next, I ask that Exhibit 8 be entered into the record. This slide provides examples of letters sent by the board during the last 5 years that include worker safety issues. Most recently, in a letter dated June 4, 2018, the board noted the high mitigated radiological consequences to workers for a number of accident scenarios at the Savannah River site's tritium facilities. Several of these accident scenarios have calculated dose consequences in the thousands of rem total effective dose to the co-located worker. The board stated it was concerned that there is a need to evaluate and implement additional safety controls for the protection of workers. As you can see from the other examples on the screen, the board has routinely sent letters identifying safety items with regard to workers and which the department took action to correct. I ask that Exhibit 9 be entered into the record.
And Mr. Rossetti, just for correction, I think your exhibit numbers are not matching the slides. We are looking at 12 now. The last one was 11, and the first one was 10. So we can make that correction.
Yes, sir. So Exhibit 12 be entered into the record. Of note, 21 of the total 41 board technical reports deal either in part or exclusively with worker safety. As listed in Exhibit 12, two clear examples of this practice include Technical Report 20 and Technical Report 29. Next, I ask that Exhibits 1, 2, and 3 be entered into the record. These exhibits illustrate the importance of workers in implementing administrative safety controls. In closing, I note that the interface order potentially limits the board's access regarding all of the examples I have covered.
Thank you, Mr. Rossetti. So Mr. Maury, is it the department's position in its order that the board is prohibited by statute from transmitting correspondence or reports to the department or to Congress on issues that impact workers?
No, it is not. The department welcomes any issues that the Defense Board has relative to worker protection. If you see issues that are a part of your reviews as you're going about your review and you want to provide those to the department, we welcome those. We want to know about issues that are going on in our facilities. You have talented staff that are out in the facilities. You have resident inspectors that are there all the time. We need to know the information and the things that they are seeing. The only position that we are taking is relative to the formal board recommendation process and whether or not worker protection should be an element of that recommendation process. And the department's current position is that worker protection is not a part of that. However, those issues should be communicated one way or another, either to the on-site personnel, to the secretary, to whoever.
I'm confused by what you just said. The department's position is that issues involving worker protection should not be a part of formal recommendations? For instance, we can talk about the tritium, the draft tritium recommendation.
That's correct, and I think if you recall the secretary's response to that draft tritium recommendation, he annotated that the tritium element of that recommendation was a worker health and safety issue and was not appropriate for the recommendation.
Well, actually, what the department said is, in light of the limitations on the board's authority under some enabling legislation, we could not speak about it. That's what the letter actually said. So it was, the department took the position that it was outside of the board's authority to speak on worker protection. Did I read that wrong?
No, that is my intent. You're more eloquent than I am, so I think that's appropriate.
So has the department concluded that the board must be silent on issues impacting worker health and safety?
No, I said as before, that if you have health and safety issues relative to workers, communicate them. Communicate them to the department.
So can you,
Are
Please
you-
tell
are
me
you
again.
Are you implying that the only vehicle for communicating those issues is through a formal board recommendation to the secretary? You have other tools available to you to communicate issues to the defense.
but
to
we
the
decide what
department.
tools we use to
Correct.
communicate.
Correct.
So what I'm misunderstanding, or I'm just not quite getting, what is the difference? Well, I'm
Well,
really trying
the
to understand,
difference-
what is the
The
difference?
difference between a letter that is provided to us and we are to evaluate those issues and take action as appropriate as compared to the formal process of a recommendation are quite significant in the terms of the resources that the department applies to that.
So let me just
Administrative resources and the people that are applied to it.
So let me just be clear. If the board is evaluating, let's just say adequate protection of the public, which is exactly what we said in that draft recommendation, because of the vehicle, the department will not accept it.
Define accept.
Well, we talked about an example earlier.
When you say we will not
Reject.
accept, we will not accept the
The information.
comments. No, we will accept the information, and we will evaluate it based on its merits. All I am saying is that it will not be handled through the formal recommendation process.
And that is why? Tell me again, I'm missing.
Because the formal recommendation process, from the board's perspective, is dealing with public health and safety, not worker health and safety.
Well, the board's perspective is that everything it does is done to ensure adequate protection of the public.
Well, clearly, the tritium example that you referenced was not a public health and safety issue.
So let me go to Mr. White, who is itching to speak anyway. Let me ask my question, you can say whatever you want. Does NSA rely on worker actions, qualifications, reliability, presence to execute protective actions to ensure protection of the public at your facilities, any of your facilities?
Yeah, we have any number of facilities where the workers are a very important part of our safety management programs.
So you rely on the worker as a part of your mosaic of to ensuring protective actions are in place and taken to protect the public.
That's correct.
So why would the board not evaluate the same.
But again, as Mr. Mowry pointed out, there's a difference between how we choose to address an issue that you raise and whether or not you raise it and whether or not we respond. In the case of the tritium issue that you discussed at Savannah River, I mean, we're continuing to work to improve those safety basis documents and get them up to date, and we're keeping your folks there up to speed on where we are. So the fact that we chose not to respond to it via an implementation plan doesn't mean that we're not continuing to address the underlying concern that you had. And in that perspective, your recommendation also didn't make the connection you just made, right? So the recommendation that was sent to the board did not actually make the connection that you just made, which does tie directly to public health and safety. And so if your recommendation had made that connection, that's a different thing than about being simply about the protection of the worker.
So can I quote for you the
Yes.
board's draft recommendation? Page 1. Recommendation 2018-1 identifies the need to address deficiencies in the safety basis for facilities at the Savannah River site related to atmospheric dispersion modeling, methodology, and implement safety measures as needed to provide adequate protection of the public, including, in paren, co-located workers and workers with responsibilities for ensuring adequate protection of the public. We thought we did make that connection.
Okay, all right.
That's what I want to say. Okay.
Ms. Roberson,
Okay.
Mr. Santos has a clarifying question. Very briefly, please.
If you allow me.
Yes.
Okay. So if we take the example of, if you can put out the recommendations that deal with worker safety, Mr. Rossetti, what exhibit was that? So if we take the second bullet, recommendation 2012, Savannah River site, building 235F, which was actually, approved, sent, and responded by the Department of Energy. Is the position that, given the new construct and the new order, that recommendation will have not been accepted by the department and with an implementation plan developed?
And certainly, the 2010-1 relates to public protection as well as protection of the workers, so I don't think that would be a
2012-1.
question. I would have to go back and look at what that recommendation is. Without going back and looking at it in detail, I wouldn't know, but I'm happy to sit down and talk to you after doing that.
It's still open, by the way.
Ms. Roberson.
Okay, so, Mr. Mowry, for my next question, the statute doesn't specify the safety systems or protective measures utilized to ensure adequate protection of public health and safety. The statute doesn't specify that the board shall provide oversight to ensure the health and safety of confinement ventilation systems or fire protection systems or any of the other systems that are relied on. So, and it's even further complicated by the fact that there is a growing use of administrative controls, i.e. worker actions, and in some cases, to my dislike, more reliance on administrative programs, not just discrete actions, but programs which are executed by the workforce. So all versus passive engineered features, which we all know if we had passive engineered features would be we might have a different view, but we don't. That's not what we have to deal with, the infrastructure we have. So why is the department's interpretation that the health and safety of the workers should be exempt? And you can say in recommendations, I don't get the difference in the vehicle, but the way your order reads is, we can't look there, and that's how I read your feedback to the board on the draft recommendation. Maybe I'm wrong, maybe that's not your intent, but why would it be exempt?
Well, you're talking about specific controls. I mean, you're talking about specific admin controls that are in place to ensure adequate protection of public health and safety, and we have never said that the board cannot look at those controls that are put in place. Part of the problem that we have in the department, as you know, is the aging infrastructure, and sometimes design controls or passive controls, we are not able to put those in place. So the default position, unfortunately, in order to complete the mission that the taxpayers expect us to complete, makes us put administrative controls in place. And we have a very specific process for ensuring that those controls are in place and maintained. And certainly they are not the first priority as the hierarchy of controls articulates, but they are a necessary tool that we have to use on a periodic basis.
And I absolutely understand it. In fact, in 2002, I don't know what exhibit it is, the board actually brought this to the department's attention, which I think maybe both of you are still here. The board issued a recommendation to prod the department into creating more discipline around its use of administrative controls. But we are also starting to rely on administrative programs, which are not discrete actions as well, too, in that venue. And so we all know the infrastructure we have. And I don't disagree with anything you said, but I'm trying to understand, having been dealt that hand, what's the deal with the board can only communicate a certain way on worker safety? That's what I'm trying to understand. Okay. So my last, did you want to say something, Mr. White? Okay. So the last point I wanted to make was, and we've had great conversation, and you guys have provided some interpretations that are different from reading the plain language of the order. And so one of the things I just want to bring to your attention and would ask you to just confirm in this hearing is that I need you to verify that you are sure this interpretation, as it relates to worker safety, is not a signal to workers at defense nuclear facilities to not communicate worker safety concerns to the board or staff, because the department's view is that the board has no statutory authority to evaluate those.
So I will, for NNSA, I specifically addressed that question at the training session I gave for our folks, and I asked them to reinforce our perspective, which is that folks who want to raise safety issues are free to raise them in whatever avenue they think would be most appropriate and most effective at getting them addressed. Certainly, we hope our plant and laboratory employees feel comfortable raising them with their leadership. If they don't, they're welcome to raise them with the department. If for any reason they don't feel they're comfortable raising them with the department or their own leadership, they're welcome to raise those to you or your resident inspectors, and we will address those as they come up. But there's certainly no intention to keep folks from raising safety issues that they see at our facilities. We encourage that. We would want that to happen.
And I believe what Mr. White has said is fully consistent with both the Secretary and the Deputy Secretary's personal commitment to excellence in health and safety, and with the Chairman's permission, I'll submit that for the record, their commitment. But it is that they are encouraged to raise any issues that they may have, and as Mr. White has noted, if they are uncomfortable raising those to their current management, there are a broad variety of other venues, both within the department and outside the department, that they are welcome to do that, and they are going to do that without any retaliation or fear of retribution.
I said that was the last thing I was going to say. This is the last thing I was going to say. I thank you for that, but I think the point I'm trying to make is what you intend and what's in writing sometimes don't jive. And I'm just telling you, you really need to look at how you communicated that message.
And if I would just add to that, I would appreciate it if you would write or communicate those specific areas where you think that what we have communicated to you is not in compliance or not aligned with the order itself. We are open to your input. We want to make this work, as the deputy said. We believe this relationship is important. We are a team, so to speak, but we each have our roles that we have to fulfill. So if you could provide those to us, and if we feel that it's necessary to change the order, there is nothing that precludes us from doing that.
Thank you.
Mr. Santos has a follow-on question, and then I do. So, Mr. Santos.
Thank you, Mr. Chairman. And thank you, Mr. Murray. I appreciate that willingness to remain open for formal input from the board. And I want to follow up on that because listening to all these discussions, it is clear to me that we're having different interpretations of the board enabling statute and some aspects regarding the importance of worker safety. And given your last statement, Mr. Murray, do you consider that it will be prudent for the Department of Energy to simply withdraw DOE Order 140.1 until this administration seeks additional clarification from Congress?
No, I don't, not until we get clarification from, I mean, if the Congress elects to change the Atomic Energy Act, then we will certainly comply with the Atomic Energy Act. This is our interpretation. Your general counsel is involved, our general counsel is involved in interpretation of the public versus worker safety, and I will leave it at that.
Do you consider that it would be prudent for the Department of Energy to withdraw the order and seek input and feedback from the public and other interested stakeholders, which includes the board?
I do not, because I believe this defines the responsibilities for the Department of Energy's federal employees and contractors. Having said that, if there is confusion on the part of the board or areas of the order that they think are not in alignment with what we have been talking about, then we are looking for that formal input.
Thank you. Mr. White, do you consider that it would be prudent for the NNSA to freeze implementation of the DOE order until this administration seeks additional clarification from Congress?
No, I don't think that's necessary.
Do you consider that would be prudent for the NNSA to freeze implementation of this order and seek input and feedback from the public and other interested stakeholders?
I don't think it's necessary.
Okay. Mr. Rossetti, do you consider that it would be prudent for the board to formally request that the administration seek clarification from Congress regarding the various interpretations of the board's enabling statute and potentially the Atomic Energy Act?
Could you please repeat that question, sir?
Yes. Do you consider that it will be prudent for the board to formally request that the administration seek clarification from Congress regarding the various interpretations of the board's enabling statute and potentially the Atomic Energy Act?
Sir, I think it's one avenue the board could pursue. In my role as the technical director, I think it's up to the board to determine what it thinks its authority is and make decisions regarding the adequate protection of the public health and safety and provide that information to the department, to the Secretary of Energy, in whatever vehicle the board determines is necessary.
Thank you for that answer. I agree with that answer. Mr. Murray, could you please explain the process for the board or any member of the public to formally solicit changes to Order 140.1?
141 is posted on the website, and on the website there is a point of contact. My office is the Office of Primary Interest, and they can provide comments to the Office of Primary Interest on any concerns they might have. I would like to say one thing on your previous line of questionings. If you recall, we were operating to a 17-year-old manual that I don't think any of you would disagree is no longer compliant with the law. It does not even address the board's new process for providing recommendations to the board, draft recommendations. So we are not comfortable with having a document that we are following that is not in compliance with the law.
I do not disagree with a lot of what you said. When it comes to what I call transactional aspects, the part that is getting my reaction is the changes to the role of independent oversight and the different interpretations of the board's statute and the Atomic Energy Act. Thank you.
Ms. Connery.
Do you have a similar order for your relationship with the General Accounting Office?
I believe we do have an order that governs our interface with the IG and the GAO from an audit perspective.
Were they involved in the development of that order?
I couldn't answer that question for you.
Thank
We'd have to take that for the record.
Continuing on in this line of inquiry, I have one final question. Could we put up Exhibit 10 again, please? And Mr. Rossetti, could you remind us again of the second recommendation, 2012-1? Can you tell us about that, please? Just to set the table.
Yes, sir. So recommendation 2012-1 concerned Building 235F at the Savannah River site. One of the accident scenarios had calculated unmitigated dose consequences to the co-located worker that were 27,000 rem total effective dose. The department's directives generally require safety controls when potential worker exposures are in excess of 100 rem total effective dose. And when the board sent this recommendation 2012-1 to the department, there were approximately 1,000 workers near Building 235F, or people near 235F.
Thank you. And this was long before my time on the board. Am I to understand that this recommendation was all about worker safety, co-located and worker safety? Is that the total set of the concern?
Sir, I would have to review the recommendation to answer 100% affirmatively, but I think so, yes, sir.
But certainly, would it be fair to say that a big chunk of this recommendation was about workers?
Yes, sir.
Okay, so this is the same question that Mr. White was asked a minute ago. I want to give Mr. Mowery a chance to give his response. If the board were to offer this recommendation or one like it today, what would be the department's response?
I would, assuming there are no public health and safety issues, and I like Mr. Rossetti, would have to go back and look at it again. This is the feedback we would want from the board. I mean, this was not an unknown issue at the site. It was being put into their risk ranking and going to be addressed as their funding allowed. But we would probably have taken the exact same actions that the implementation directed us to, because this is an issue that the department recognized we needed to deal with. All I'm saying is that there wouldn't have been an implementation plan where we have made specific commitments to the board to address.
You did make commitments here, correct?
And that is part of what the deputy was talking about, is aligning what the specific roles and responsibilities and ownership of the department are relative to areas that are outside or that he considers to be, where the buck stops with the department.
Okay, I'm having a lot of cognitive dissonance between what you just said now and what we discussed about 10 or 15 minutes ago, where when Ms. Roberson's line of inquiry about your saying that we have to have other mechanisms other than a recommendation if we're talking about worker safety. So I don't need to probe it further. I'm not clear on what that is, but that may be just my problem. I'm going to let Mr. Santos ask the final question here on this line of inquiry.
No further question.
Okay.
I just want to clarify, what you're saying is that you wouldn't have taken this recommendation, you would have likely have performed the same functions, but not as an implementation plan.
That's correct.
And who writes an implementation plan?
Well, there's a responsible manager that's put in place. The responsible manager
But the
puts
Department of
together a
Energy
team.
writes the
The Department of Energy writes the implementation plan as approved by the secretary.
So it's still the Department of Energy's plan. The board doesn't impose the implementation plan on you. You choose what to put in the implementation plan after evaluating the information that we give you to address the issues that we've raised.
That's correct.
Ms. Roberson.
Mr. Chairman, can I just add one clarifying point or question, which is really apropos since we have 2 former board employees, well, 3, 1 current, 2 former. When we talk, whether we're talking about 235F or tritium or anything else, the board doesn't pop out of a balloon with a recommendation. The board works sometimes for years trying to encourage the action that it believes is necessary. And so I just have to say, the board uses its tools very deliberately, but we don't surprise the department. So if we raise issues, whether it be informally or through letters, and we see action, we tend not to issue recommendations. We issue recommendations when we don't see that action. And that was the case on 235. Everybody knew about the issue, but the board had been, the board, not just the board staff, been prodding. We had hearings for several years. So I just want to make that clear.
Thank you, Ms. Roberson. The chair recognizes Mr. Santos. Tim.
Thank you, Acting Chairman. It appears that the new order makes the process of interfacing with the board more bureaucratic, less efficient, and one that could impact safety by delaying the ability of the board to provide timely information to the Secretary of Energy. This seems contrary to the intent of regulatory reform activities under Presidential Executive Order 13777. For example, in addition to limiting interactions with the board, the department is introducing additional bureaucratic approval steps for each specific request of information or access. Furthermore, all board requests need to be referred to and approved by appropriate federal departmental site liaison prior to providing a response back to the board. Mr. Maury, has the department taken actions to ensure that every site has a federal representative that will respond in a timely manner to information requests?
Yes, we have site liaisons at each of the site. They have a monthly meeting with Mr. Joe Olins. He discusses issues dealing with the board, making sure that we are providing appropriate support. There are no additional bureaucratic steps that you're alluding to. The request for information process is identical to what has been in place before. We have always asked that the Defense Board deal with our Department of Energy and not directly with the contractors. The contractor's contract is with the department. It is not with the Defense Board. So it's important for us to understand exactly what is going on when they're dealing with the Defense Board.
Could you provide for the record the list of the federal representatives?
Yes, sir.
Thank you. Will this be implemented consistently at all sites, or will there be different processes for interfacing with the board and its employees at each site?
We have a pretty extensive training program. The rollout slides are on the website, the departmental rep website, so they are available for you to look at. And, sir, I'd be happy to provide those for the record if you would like those. So yes, and this topic is discussed, as I said, every month during these liaison meetings.
Let's stop for a moment. We have some audio interference. I'm not sure
Yes,
what
sir.
that is.
Not me.
Okay, let's go ahead. I'm sorry.
I'm sorry, I've totally lost my train of thought. Yeah, that was just
Now you
too
were talking
disruptive.
about the slides being available.
Yes. Yeah, they are available to you. And we have had several training sessions. If I'm not mistaken, all of the liaisons have been trained. And as I mentioned in my opening, in my first comment was, we want to be institutionalized and consistent as we apply these processes across the complex. Because I think you're all well aware that there are certain sites where it is more difficult to deal with the Defense Board, and we want to make sure that everybody is approaching this from the same perspective and with the same approach.
Thank you. Mr. Rossetti, what impact do you see from any changes in practices, particularly for the resident inspectors that need ready access?
Sir, I see potential for two significant impacts. First, I think the process could introduce unnecessary delay in providing the board information needed to perform timely analysis of matters that impact safety. In particular, the process requires departmental staff to be the focal point for all information requests. Previously, site contractors were expected to respond to requests while keeping the department's field office personnel apprised. My concern is exacerbated by the fact that many of the departmental site liaisons are senior federal officials that are already facing constraints on their time prior to trying to fulfill this administrative burden. For example, at the Los Alamos National Laboratory, the senior nuclear safety advisor serves in this role. Second, I think this language could impede the ability of our resident inspectors to meet directly with department and contractor staff. I believe our resident inspectors require direct, ready access to facilities and personnel to inform their safety assessments and ultimately the board.
Thank you. I agree that ready access is extremely important for the resident inspector, given their unique function as the eyes and ears of the board in providing direct oversight. Their functions are clearly different from the functions performed by the rest of the board staff. However, the desk reference for the new order doesn't recognize this when it states, and I quote, "In all cases, the resident inspectors are the same as any other member of the Defense Nuclear Facility Safety Board, and the same protocols for requests for information and meetings should apply." Mr. Maury, what is the department's interpretation of the responsibility of the various DOE elements to provide ready access to the board resident inspectors?
Well, I think the reading of that statement is true. The resident inspectors are members of the board staff. It just so happens that they have unescorted access to the facilities. They're at the facilities. They have access to the facilities' computer systems, the LANs. They have access to a broad plethora of information. What we're asking is that they work with their liaison on how they are going about their business so that we know what's going on. But there is no debate that they play a very critical role, not just for the Defense Board, but also for the Department of Energy. And I think Mr. White would probably talk to you about how NSA is approaching the resident inspector program.
If you can follow up the question with Mr. White.
Yeah, I mean, I spent 4 years as a resident inspector for the board at Pantex, so I have firsthand knowledge of what it takes to do that job. And I've communicated to our folks that, you know, we're to continue to give those resident inspectors ready access to facilities, to people, to plan of the day meetings, to shift turnover meetings, all the things that they would have had access to in that regard previously. The request that we move document requests through a departmental liaison is no different than what I did when I was at Pantex. All of my document requests got copied to, I think the gentleman's name was Mike Rika, who is a POC for the site office. And I did that in part to make myself more effective, because having the department aware of what I was looking at and what I was interested in actually helped ensure that if I ran across issues, that I could be more effective at getting those addressed.
Thank you. Mr. Maury, earlier you mentioned, and I agree, that you mentioned that the DOE order applies to the DOE elements. It's an order for DOE elements, and it doesn't appear to impose any restriction on the board, on its staff. But we're having that type of discussion right now. When will and since one order, DOE order was issued, you know, no formal input has been provided, you know, by the board yet. But I would like to know, when will the department formally communicate to the board any new protocols, processes, and requirements that the department will apply to board personnel, including resident inspectors, headquarters personnel, and even board members, for us to carry out our independent oversight work at the defense nuclear facilities which you own? All we have is the order.
Yeah. If I understand your question correctly, I don't anticipate us communicating to the board on changes that are going to occur on how we deal with our resident inspectors. If that were to occur, certainly we would come and talk to the board and discuss any changes that might be occurring, but I don't anticipate that occurring.
Ms. Roberson.
Yeah, just attaching, I appreciate what you said, but I know that you also know you have thousands of soldiers out there interpreting your order themselves. So, for instance, plan of the days. Our resident inspectors are there to have eyes on and ears open. And if they are not allowed access, if people consider plan of the days pre-decisional, then we don't have access. I guess what I'm asking is, I understand you guys are doing a lot of training, and you're saying, well, if we find, we don't have enough soldiers to go out and find all the problems. We certainly have identified some. I guess my question is what check are you guys doing to make sure that your order is being implemented the way you intended it to?
Well, in addition to having a formal set of training slides that goes through this, our monthly discussions with the liaisons to go through this to make sure that it is being implemented consistently across the complex is our key method for doing that. As well as, let me just add also, as well as Mr. White providing additional training to all of the facility managers, and I know that EM and Science have done the same thing.
I mean, I'll just say that if you run across examples of where our implementation is not consistent with the way that I have described, then by all means, please bring those up to me or have your folks bring them up with myself or Mr. McConnell, and we will take action to correct that.
Thank you.
The chair recognizes Board Member Connery for the last line of inquiry. Ms. Connery, you can do both of them.
So the Secretary of Energy's responsibility under the board's enabling legislation limits the ability of the Secretary to deny access to information to any person who, and I quote, has not been granted an appropriate security clearance or access authorization by the Secretary of Energy or does not need such access in connection with the duties of such a person, end quote. This contrasts with the interface order, which allows the department to deny requests related to deliberative documents, pre-decisional documents, or deliberative meetings. Mr. Rossetti, can you give us some concrete examples of where limits on access to information could impede the board's ability to identify safety issues, including specific impacts on resident inspectors?
Yes, ma'am. I'll provide 3 examples where these limits might impede the board's oversight. Foremost is emergency response. By the very nature of an emergency, information flow is highly dynamic and often insufficiently vetted such that the department could conceivably consider it pre-decisional. The board could be forced to wait for such information which would preclude timely board recommendations and advice on the matter. Second is safety basis documentation. I understand that some sites have already started to treat the management and operating contractors' submitted safety basis documents as pre-decisional. To be clear, these documents are formally approved by contractor management and have been submitted to the department for approval. Historically, this is the point at which the board staff has most effectively reviewed documents such that issues can be raised during the course of the department's review and any safety concerns resolved promptly. This approach avoids significant delay in resolving a safety concern and the potential rework associated with raising issues with fully approved and implemented safety controls. Third, the access to information language may impact the board staff's ability to monitor the adherence to the department's and its contractors' processes and procedures. Often steps involved in following a process occur in forums that could be constructed as deliberative. If the board staff is denied access to these meetings, we'll be left to assess process adherence simply by the overall outcome. As such, we'll be unable to provide the board assurance that the department and its contractors are operating in a manner consistent with procedures and best practices. As an example, DOE contractors typically hold some type of fact-finding discussion to learn from and improve after the occurrence of an abnormal event. The board's resident inspectors observe these discussions and are able to provide an assessment of the thoroughness and conduct of the fact-finding meeting, including whether the contractor adhered to its own process requirements. If the resident inspectors are denied access to these fact-finding meetings, the resident inspectors will be left to assess the event solely from the final report and corrective actions.
Thank you, Mr. Rossetti. So I'd make 2 points. You've been very vociferous about the fact that this order is about roles and responsibilities, and that it is the role of the department to operate the facilities in the defense nuclear facilities, as well as play the role as a regulator. The board's role is oversight. We are to advise the secretary in his role in assuring adequate protection, which means that it's our job to make sure that the Department of Energy is regulating its contractors as it should to meet those requirements. In order to do that, we have to have access to these meetings and this information prior to decisions being made. Additionally, I would submit that if you're making decisions that are, and you're asking for our advice after the fact, then those are by definition uninformed decisions, because it would be better if we gave you the information ahead of time. In particular, the Congress has weighed in on this in terms of design and construction and has asked us to provide information early and often so that you don't have to go through expensive design changes, but can take our advice early in the process. So given Mr. Rossetti's testimony, Mr. White, can you discuss whether his interpretation of the order is consistent with NNSA's intended implementation relative to pre-decisional and deliberative information?
Sure. And I don't think it is. So, and I addressed at least parts of what he discussed very specifically with all of our sites to make sure that we had a fairly uniform set of expectations with regard to how we implement this. So on the safety basis documents, for example, the point at which one of our plants or laboratories has submitted a complete work product as a deliverable to the government, I would agree that that is something that we should share with you. And that is what all of our sites have been directed to do. So the point at which our plant or laboratory believes that it's good enough for the government to approve, then it is a good enough finished work product for you to begin review. The thing I have suggested that they should work with you on is the best timing to support an in-depth staff review of that document. I think from our perspective, we would like to give our federal folks in our site offices or on our safety basis review teams sufficient time to review the document themselves and develop a department position relative to the quality of that input before we engage with you. But we will engage with you before we actually implement the document. So that was sort of the high-level perspective I gave our folks relative to safety basis documents. On the question of deliberative meetings, I mean, that's one of the ones that it's in a little bit of a gray space, and we may need to talk about those as they come up. I mean, this certainly, again, when I was a resident inspector at Pantex, this came up from time to time, and we addressed those as they came up on a one-off basis, myself first locally, and if that didn't work with the board's management and the department's management up here in Washington. And so I don't, that existed, that sort of discussion existed under the previous order, and I expect it to continue to exist from time to time under the new order. I don't see that as a particular difference.
On the safety basis conversation in particular, I know that you have espoused to us that you've seen challenges with your federal capabilities with regards to looking at safety basis documents, and in often cases have to borrow staff from other locations in order to review safety basis documents. So wouldn't it be prudent sense to have the board involved as early as possible to provide our independent expertise? And if you are managing your staff, then they can either take our advice and leave it, but make the decisions on their own without relying or blaming the board for decisions that are taken.
Well, so look at this in terms of timing, not in terms of whether we eventually give you access, right? I think it is important for a couple of reasons for our folks to have some space to look at those documents and to decide what we think of them. One, it actually helps you with evaluating the quality of our evaluation process. By sort of intervening early in the process, you kind of disturb the reality associated with what the department would or would not have found in regards to those documents. And so to some extent, this helps both me and you with understanding whether our process is actually working effectively on the federal side, to let us take that time to do that internally first, so that you get a sense of, one, how well we did it, and two, that we have some deliberative space to operate in before we bring those issues up to you. The other thing I'll point out in the case of the deliberative stuff, it's not just about access and whether it's the right thing for you guys to see it. I mean, there are some cases where having outside observers actually suppresses the kind of information that we want to come up in those meetings. There are a number of folks who are involved in this sort of thing that we want to bring up potential issues. And on occasion, they may be very reluctant to do that with outside observers in the room. And so we want to protect that space for them to be able to bring up those types of issues. And when we work with these on a case-by-case basis, I'm happy to talk to you about why that would be in a particular case.
Thank you, I appreciate the response. Mr. Mowry, what is the department's definition of deliberative documents, pre-decisional documents, or deliberative meetings? Because we haven't seen an actual definition.
I believe those are exactly what Mr. White was talking about as far as having the ability to go through and make a deliberative decision on what our final conclusion is on that. Well, I say final, but our conclusion is on those documents or information prior to providing that to the board for their review.
Again, I just note that the words in the order are a little bit different than the interpretations that you're providing us, which seem a lot more benign than the actual reading of the documentation.
Well, but I think the order acknowledges that we'll need to look at these with you on a case-by-case basis.
Understood.
I believe Mr. Santos has a clarifying question. Mr. Santos?
Thank you. I understand. I appreciate what Mr. White was saying, and yes, we need to have more dialogue, and especially some of these gray areas. I understand that, but one thing I'm a little bit concerned about is regarding discussions regarding timing, because when it comes to safety vulnerabilities, timing might not be on our side, and some of these processes, as you know, take a long time. Approval of DSAs and all that process. And if our staff has already identified a vulnerability, I hope we can find a way to provide timely information to the Secretary of Energy and the public, as opposed to be caught up in the formalities and the timing of processes or waiting for final approvals before we can communicate what the issues are. I just want to leave that up.
Okay, I didn't hear a question in that.
No, it's making,
Okay. All right.
making a statement following his statement regarding that, the issues of timing.
Thank you, Mr. Santos.
Mr.
Conner.
Santos, I just want to make sure that you understand that's consistent with our thoughts as well. If you have an issue, if your board, if the staff has an issue, we would like to hear about that as soon as possible.
Thank you. The issue comes, we want to do completed independent oversight work. We don't want to be necessarily throwing out vulnerabilities that haven't been fully vetted. And that's where we get into this issue of information. At what point do we have enough of an analysis that can support the conclusions or not? And we don't want to start sending communications on potential vulnerabilities that if we had access to the information, it turned out to be, oh, never mind, as opposed to it's a real issue. Do you understand what I'm saying?
Yes, and I would actually say that's sort of mirrored on the department side as well. I mean, as we're looking at a potential change we might want to make, we want a chance to deliberate on and think about that internally before we go external and try to explain it to you.
Perfect. I understand.
Thank you, Mr. Santos. Ms. Connery? Oh, I'm sorry. Ms. Roberson?
Thank you, Mr. Chairman. I just follow on. I think the topic we're here discussing today is a great example of what we fear could happen if we're talking about hazards analysis or safety basis at a site. And that is, we didn't talk about it. You guys developed it. You're now telling us what you intended. And what you intended is not what we're seeing. And so you guys certainly have every right to make your own decisions. I've been over there. I felt the same way. But this trade-off is one you also have to make too. Eventually, you're going to have to spend the time to interface with the board. And later doesn't mean easier. That's all that I'm saying.
Acknowledged, and if in any case where you think we've gotten the timing out in a way that isn't in our mutual interest, let's talk about that, and I'm open to discussing that with you.
Thank you, sir.
And I would also say that specifically applies to design and construction activities, because your goal as well as ours is to identify safety issues and identify, the necessary safety controls early in the process as possible. So that's a perfect example of the time that we need to talk about the appropriate time for us to get together and have these discussions.
Thank you.
Board Member Connery has the last line of inquiry. Ms. Connery?
And just before I go into that, I would say that orders and directives are as important as design and construction because they govern how it is that you're going to regulate. So our input to your staff in a timely manner helps them do their job. Just a point. So my last question is a little bit broad, and I know at one point, Mr. Maurer, you said you didn't want to talk about 10 CFR 830 because it's in rulemaking right now, and that's not the subject of this. But I do notice a trend, and that's what I want to talk about at the moment. The board has been a part of the department's overall safety framework for nearly 30 years. During that time, the board and the department have collaborated to make a number of safety improvements to defense nuclear facilities that have otherwise eluded the department's internal mechanism for safety oversight. You were both a part of a number of those improvements when you were on our side of the table. What I'm seeing is a trend to change the way the department is managing safety across the board, not just with the interface order, but also with proposed changes to 10 CFR 830, the Federal Rule for Nuclear Safety Management, and its associated documents. I've heard these approaches described as a graded approach, or where you want to put more effort as a risk-based approach. Mr. Maurer, is the department fundamentally changing its approach to safety? If so, can you describe that change?
No, we are not changing our fundamental approach to safety. You know, as I mentioned, I was here for 18 years. I spent 7 years over at the department. I didn't change my colors instantaneously and think that it was necessary to make drastic changes over in the Department of Energy in their approach to safety management. I have found a group of individuals over there who are very like-minded with the board. So no, there is no attempt to change our process for safety management. It is a very robust process, much more robust than when I first began here at the Defense Board. We continue to provide that, you know, it's consistent with, or it consists of, you know, directives, and it consists of rules that are enforceable. We have the independent oversight process. We have line management oversight process. Those all remain the same. So no, we are not changing our process.
Well, I appreciate that. I don't have the same feeling, again, seeing some of the changes that were made, seeing the IPT process, cutting the board out of some of those rulemaking decisions, some of the implications that we see with 830. So I just want to make sure that you can be confident that you will be able to provide for the safety of the workers, the public, and the environment while you roll back some of the provisions through rulemaking and at the same time seek to limit the oversight role of the board.
My office, as the Office of Environment, Health, Safety, and Security, is responsible for policy. Okay, we are the advocates for policy to ensure that we develop effective policy that allows the department to complete its mission while remaining safe and secure. And we take that very seriously. So any belief that we are rolling back our position on safety and security is not true. We are not doing that. What we are doing is trying to make sure that the changes that we make are effective, implementable, and allow our line organizations to complete their missions in a successful manner as required by our taxpayers, and as how we are being held accountable, as the Deputy Secretary mentioned, but still being safe and secure.
I'd like to ask Ms. Robertson her view, since she also occupied both spaces, both here for a decade and at the department for more than a decade.
Should I go over there? Thank you, Ms. Connery. I'll be very brief, and what I will say to you is I expect to make a closing statement, and I will go toward that. The one thing I would say is I am always reminded that the department is the line manager, and they're responsible for executing programs. And the Congress is very clear that the board's primary function is to make sure that they do not become complacent in the execution of safety. And I think with some of these changes, it's very important for the board to keep that at the forefront as it evaluates its view on the number of changes that are being executed today in the arena of nuclear safety.
Mr. Santos.
I just want to add that, and at the end of the day, I just hope we have a transparent and continued dialogue. And similarly, that there's differences in interpretations of enabling statute, I see there will be also difference in interpretation on whether or not significant changes are happening to the long-standing approach to nuclear safety. And I look forward to those processes to provide my own views and comment at the appropriate time.
Thank you. We are at the conclusion of session 2. Do the board members have any final questions or comments for session 2? Mr. Santos?
No final questions.
Ms. Roberson?
No final questions,
And
Mr.
Ms.
Chairman.
Connery?
No final questions. I'd just like to thank Mr. Maury and Mr. White for taking the abuse from across the aisle.
So thank you for being here. Thank you very much. You are excused, and we are going to take about a 7-minute break, and then we will resume at 20 minutes to the hour by that clock to have the public comment session. Thank you. This is session 3. At this time, I will turn over the proceedings to our acting General Counsel, Ms. Casey Blaine, for the public comment period. Ms. Blaine.
Thank you, Mr. Hamilton. At this time, the board would like to provide an opportunity for comments from interested members of the public. A list of those speakers who have contacted the board is posted at the entrance to this room. We have generally listed the speakers in the order in which they contacted us, or, if possible, when they wish to speak. I will call the speakers in this order and ask that the speakers state their name and affiliation at the beginning of their comments. There's also a table at the entrance to this room with a sign-up sheet for members of the public who wish to make comments but did not have an opportunity to notify us ahead of time. They will follow those who have already registered in the order in which they have signed up. To give everyone wishing to make a comment an equal opportunity, we ask that speakers limit their original comments to 5 minutes. I will provide notice at 4 and 4.5 minutes that your time is about to expire. Remarks should be limited to comments, technical information, or data concerning the subject of this public hearing. The board members may question anyone providing comments to the extent deemed appropriate. The first speaker this afternoon is a former board member, the Honorable Jack Crawford. Mr. Crawford, you may proceed with your statement.
I can't hear you.
Go ahead, Mr. Crawford, you're up.
Okay. Now, you've got my list of questions, but you should have a copy. I handed the gentleman here 5. Please. Mr. Chairman, I'm here with 5 questions. As a former member of the board, I'd like to mention first the basis educationally and experience on which I asked these questions. I went to the Naval Academy, graduated. I then went to MIT, where I got a degree, MS degree in nuclear physics. So I'd like to address these questions to the same, with the basis on which I asked. I'll go to the last 2. Bear with me, I got to.
So what we can do, Mr. Crawford, is we can submit your list of questions for the record, and they will
Okay.
be a part of this hearing.
What I'd like to do is discuss 2 items, 2 questions there, and you can read them in. The first one is the directive that Congress gave to the board and when it established the board. It said the board is directed to raise the level of competence in DOE substantially. My question is, did they do that? I know that they didn't, at least in the early years, because my last year, although we tried hard to address that question, I caused a report to be prepared, or staff to develop a report, and it was an outside group, this board itself, staff, and representatives of naval reactors, retired, and also industrial groups. And they compiled a report, and the report, the board's in the board's files, because I've gotten it's called DNFSB Tech 10, you know, the DOE's technical adequacy program. And so my questions today were to be to direct that. Have they enacted it? Has the board put the heat to DOE and made them raise the level of technical competence? That's the first one. More recently, the Congress had a group examine the whole nuclear weapons enterprise, as they referred to it. It was called the Augustine Meese report. Now, the initial report, and I follow the board, what the board does fairly extensively. The initial report said that the naval reactors program was world class. I waited to see that and read that in the final report. Nothing like that. It compared the naval reactors program with other programs, but no words that would result in a raising of the adequacy of the board. So those are my two questions. What happened?
And thank you. We'll submit all of your questions for the record,
Okay,
and
yeah.
we're very
These
familiar.
ones in here.
And we're very familiar with the Mies Augustine report as well as the tech report that you
Right. prepared,
and we want to thank you for raising those questions for our evaluation, and we also want to thank you
I'd
for...
like to say, so far as I can observe, this is the first time that I've ever seen the public invited into a discussion between the DOE. I mean, if you wanted to get the issue of the technical adequacy, there was more listens. I've written to the president, told him to sort of Damocles' hand over his head. No response. One time, Vice President Cheney had arranged me a meeting with the
We
guy
have 1
who was
minute remaining.
responsible. Nothing happened.
Well, thank you. We open these to the public routinely now. So
That's wonderful.
this is nothing new
Yeah.
to me since I've been here. And again, we're going to enter these into the record. We're very familiar with the topics you brought up, and we thank you for being here
Thank you for
and for
listening
your
to me.
support. You're certainly welcome. Ms. Blaine.
Thank you, Mr. Crawford, and your questions have been entered into the record. The next speaker that we have is Ms. Kathy Crandall Robinson.
Thank you very much. I really appreciate being here. I've learned a lot this morning, and I'm happy to give these comments. My name is Kathy Crandall Robinson. I'm speaking on behalf of Tri-Valley Cares. This is Tri-Valley Communities Against a Radioactive Environment. Tri-Valley Cares was founded in 1983 by concerned neighbors living near Lawrence Livermore National Laboratory. It has worked for 35 years as a watchdog, monitoring the nuclear weapons and waste cleanup activities throughout the U.S. nuclear weapons complex. I'm also dual-hatted, delivering comments today on behalf of the broader Alliance for Nuclear Accountability. ANA is a national network of more than 30 organizations that addresses nuclear weapons production and waste cleanup issues. ANA was formed just over 30 years ago, about the same time as the Safety Board. Tri-Valley Cares and ANA are deeply concerned that this order will constrain crucial oversight activities at the Safety Board and endanger public and worker health and safety. Degradation of the Safety Board access and authority threatens to send us backwards, returning us to the days when major accidents and spills and releases were considered routine and justified in the service of the mentality of production first and safety second at best. In the 2 decades before DNFSB was created, Livermore Lab suffered major tritium accidents, plutonium fires, a burst glove box, and nuclear criticality, and numerous other mishaps. Livermore is neither unique nor the site with the worst nuclear accidents in the complex. The Safety Board has played a vital role in protecting public health and safety in carrying out its mission to provide independent analysis, advice, and recommendations to the Department of Energy. And I'm going to submit, along with my written comments, a few little highlights of some of the great things that DNFSB has done. I know that the stakeholders and the community leaders of both ANA and Tri-Valley Cares have very high praise for the DNFSB. This is not the time when concerns about the nuclear weapons complex facilities is shrinking. We have aging facilities, we have facilities that are operating with serious concerns, and we have a new drive for production that may introduce some novel problems, and I think specifically of some of the drives for plutonium pit production. 80 pits by 2030 is the goal of the Nuclear Posture Review, and you're seeing plans to greatly expand at New Mexico, as well as new plans at Savannah River. We are concerned about the limitations imposed by the Order 140.1, and that they will hinder the Safety Board's effectiveness to fully investigate and continue with sound oversight. We believe that the order is at odds with the enabling legislation that states, as this was pointed out earlier, the Secretary of Energy shall fully cooperate with the board and provide the board with ready access to such facilities and performance. Sorry, just 1 second. Such personnel and information as the board considers necessary to carry out its responsibilities. We are particularly concerned about 3 constraints.
You have 1 minute remaining.
Okay, I'm going to go fast then. The first is the hazard category 3 facilities, and these were discussed in the interaction of that with what happens within the site. And I just wanted to point out particularly that the Livermore site, the public is so close to the facilities that they are closer in many cases than co-located workers.
30 seconds remaining.
I am going to skip through very quickly. So it's the access to facilities, the category 3, and this is very much related to whether we include workers and the publics. We think that they are absolutely linked. You cannot separate them. The pre-decisional documents, we don't know what that means, but we're very concerned, especially when it comes to the construction issues that were mentioned, but all the others.
Would you
And then,
please conclude
finally-
your statement, Ms. Crandall Robinson? Would you please conclude?
Yes, I will conclude.
Thank you.
I will conclude by saying that the final thing is the access to contractors and work with the site workers, and that we have asked the Secretary of Energy to revoke or at least hold in abeyance this rule, and very much thank the DNFSB and rely on your continued diligence.
Thank you. If you have copies of the documents that you would like to submit for the record, I have an associate who will come and retrieve them from you. Thank you. The next speaker that we have is Seth Kirschenberg. You should go back there, please. Thank you.
Great, thank you very much. First, there's a lot of irony here that you are holding this hearing, informing the public about this DOE order. And I want to thank you very much for actually holding this order. My name is Seth Kirschenberg. I'm the Executive Director of Energy Communities Alliance. We represent the local governments and local communities around the various Department of Energy facilities, and we submitted a letter that we sent to the Secretary of Energy today on the record that basically asks him to pause this particular rule. ECA's goal is to ensure the DOE and NSA complete their jobs effectively, efficiently, and safely. We believe that the order does not accomplish these objectives, and today you highlighted many of the concerns that the communities have, and we really appreciate it. I learned a lot today, and I think the communities learned a lot today. In our formal letter, when we asked that it be paused, we identified some key issues. One is, you've got to involve the community. I mean, that is a key issue when developing any of these policies, especially when we talk about public health and safety. But more importantly, I think that, as you talked about before, one of the key things is involving DNFSB. Your working relationship is the reason why processes can move forward, either clearly or not. And them understanding those things and them understanding how you actually work together are actually it's clear. I, who have seen the Department of Energy litigate cases, fight against regulation, and then learn over and over and over again that by working with the regulators and oversight, that they create these efficiencies. They create processes that actually work. What's interesting, we became aware of this order because obviously a lot of different people started raising concerns. We started getting questions about it, not because DOE actually said, hey, we've got this new order that impacts, and they said it, health and safety of the community, which they're trying to focus on. And we agree with you related to the worker issues as well. Since DOE doesn't have a formal regulator related to the issues that you all oversee, DNFSB to us plays a critical role. We've seen that over time. The information that you provide to communities and to the public is very key for us. For this reason, we're concerned about 140.1. ECA believes the new chain of command, and it was interesting to hear Mr. White talk about, well, when I'm briefing them, this is what I'm telling them to do. We all know of anybody who's ever worked with government that the next person reads it and says, that's not what this says. Here's a pre-decisional information. I'm not supposed to give this to you. Pre-decisional is very defined in FOIA and other types of things about access and information that the department actually discloses to third parties. And it becomes very clear that we're going to have concerns. The other thing that you have is NNSA, EM, Office of Science, everybody else, they implement these rules differently. And they are going to implement them differently. And when you have a site like Oak Ridge that has actually one landlord with 3 major operators, how are they all going to implement and require and respond to all of you? The one voice comment that they made in the order means lessening of diversity of opinions to us that may exist between DOE personnel and DOE contractors. And we all know that if you've worked within the system, that people have different ideas on different information as we go forward. We appreciate the desire to save costs, streamline processes, maximize efficiencies. We want to accomplish the same goal. In the past, we've sent comments to DNFSB about improving those particular processes, and we will continue to do that as well. But implementing an order that limits interaction and
1 minute
opportunity
remaining.
for oversight will not achieve these objectives. We urge DOE to pause this. The hearing really raised more questions for me and confusion, actually. And I'm someone who actually follows these things and works on them regularly. And so, we want more information from the Department of Energy on the worker safety issues, the oversight of sites like WIP. How could you not have oversight of
30 seconds
some of
remaining.
the most critical, important infrastructure within the Department of Energy? And so we actually are going to be asking the department of the same things. I just want to close by just saying thank you very much for holding this hearing. This has been very informative, and we look forward to working with you in the future. Thank you.
Thank you for your statement, Mr. Kirschenberg. If you have any documents that you'd like to submit for the record, please give them to my associate. Thank you. Are there any other members of the public who wish to speak at this time? Seeing none, I would like to thank each of our public commenters for speaking this afternoon. And at this time, I will turn the proceedings back over to Acting Chairman Hamilton for closing remarks.
Thank you, Ms. Blaine. I will now turn to my fellow board members for their closing remarks, and then we'll end with my own closing remarks. Ms. Roberson.
Thank you, Mr. Chairman. I want to thank my fellow board members, the Deputy Secretary, and other departmental representatives that were here today, our staff participants, and most importantly, the public here and online for your support and participation in this hearing. As has been noted, this is the first in a series of hearings on this topic, hopefully to be followed soon with the focus on execution of DOE's Order 140.1 at environmental management, defense nuclear facilities, and the Science Defense Nuclear Facility. This serves as our first real opportunity to critically understand the intent and goals that the department and its line elements have sought in redefining its relationship with the board and the board's execution of its oversight authorities. I and fellow board members are very much aware that about every 2 years there's a new or revived study that advises the department that it is spending too much money in response to the board and the board staff, and generally advises the department to shore up in-house control of expenditures and responses to both informal and formal communication from the board or the board staff. And I recognize their right to manage their internal business. Board members now and in the past have long been concerned about the DOE application of board-recommended actions being applied across the entire department. The board provides oversight and insights to the Secretary specific to defense nuclear facilities. The application of those standards to other DOE operations or activities is not the board overstepping its authority. Those have been DOE internal decisions. We recognize the management challenge when you have such a diverse portfolio for the board, but the board has previously actually written to the department expressing its concern that the application of the same expected high safety standards for defense nuclear facilities may be an overburden for non-defense nuclear facilities. The department elements have, to their credit, built-in avenues like waivers or exemption processes to allow acceptance of different requirements with thoughtful reasoning, but those are rarely used. And I do not know why, because the alternative we now see may lead to normalizing safety requirements for defense nuclear facilities with non-defense nuclear facilities. The board and DOE have had a lively relationship since the beginning, and I think that has been and can be very healthy as long as the relationship is focused on technical debate and technical perfection, as former board member Crawford highlighted, and is focused on how the public is protected in the execution of the missions essential to our national defense. And there is no analysis that will silence the board, even if it's not this board. I am very concerned with the department's stance regarding the board's authority to evaluate, advise, recommend, and speak to matters involving worker, co-located workers, and public health and safety, and be assured the department will treat board communications with the due consideration it deserves. We all understand that the department is accountable for managing the integration of safety at its defense nuclear facilities. The board provides independent oversight. At the end of the day, it is the Secretary's decision and communications regarding the department's commitment to safety that prevails with its workforce. But accountability and transparency must be hand in hand. The department has decided to independently invoke its interpretation of the board's enabling statute, and even though the board already takes issue with some elements of the department's interpretations, we have not yet received any formal communication regarding why it has taken those positions, and even more importantly, what are the new requirements the department desires to impose upon oversight. This is unfortunate and leaves too many important questions regarding the department's intent toward independent oversight to speculation. I hope the board and the department can take actions to address this very soon. Thank you very much.
Thank you, Ms. Roberson. Board Member Santos.
Thank you, Acting Chairman. First, I want to thank all the participants in today's hearing, especially all the DNFSB staff and support personnel that worked very hard in the preparation and coordination of this hearing. So, thank you to all of you. In addition to Order 140.1, it is important to note that the department is systematically changing key aspects of its long-standing approach to nuclear safety and its views of the role of independent oversight. And while these changes are taking place, the department is facing tremendous pressures, challenges, and issues throughout the defense nuclear complex, including but not limited to aging infrastructure issues, deferred maintenance issues, human capital shortfalls in critical safety programs, technology and construction issues and delays, conduct of operation challenges, events, upsets, and incidents, and the need to execute upcoming high-risk work, such as plutonium remediation work at the Savannah River site and at Hanford. Given all these issues, challenges, pressures, and systemic changes, I consider that this is not an opportune time to be altering aspects of the role of independent oversight that for many years have helped serve as a strong pillar relied on for providing adequate protection of the American people, including the American patriots that work throughout the defense nuclear complex. It is not clear to me what gives DOE confidence that safety will not be compromised. These are the types of issues I will continue to explore. DOE has a safety infrastructure that was built over many years with a lot of technical study, expertise, lessons learned, and best practices. It is my strong opinion that the DOE enterprise needs to resist the pressures to make significant and hasty changes to it. I encourage the DOE leadership to be skeptical of any changes to its safety approach and to ensure that erosion of safety is not disguised as promised improvements, promised cost savings, or to quickly buy into shallow statements that failure to deliver on mission is due to adherence to safety. I encourage DOE to continue its strong relationship with the board and to always remain open to the board's independent analysis, advice, and recommendations. Now is not the time to be limiting interactions with the board. I repeat, now is not the time to be limiting interactions with the board. Fellow board members, as you all know, we're facing challenging times at the board, and we need to even be more vigilant and conduct our thorough independent safety oversight work in an effective and timely manner, as all these changes are taking effect right now. The American people deserve it. This concludes my statement. Thank you.
Thank you, Mr. Santos. Board Member Connery.
Thank you, Mr. Chairman. I'd like to thank my fellow board members and associate myself with the closing remarks of Ms. Roberson and Mr. Santos. I thought those were excellent and eloquent remarks. I'd like to thank the public for tuning in today or showing up, and particularly those who sought to engage with us with public remarks. I also want to thank DOE. You've done the impossible. You've brought the board together in a unity for first time in a while. So congratulations on that. And to echo some of the themes that I've heard from my fellow board members and from some of the public, you know, these aren't fantastic times to be reconsidering how we do safety. We are in a situation in which there's aging infrastructure, where there's a changing workforce, where there's increased an important mission at NNSA, and there's more complex mission left for EM to do. So this seems to be the perfect storm for accidents to happen, and this is a time where we should be doubling down on our efforts on nuclear safety. When I was speaking to the Department of Energy's facility rep gathering in Las Vegas last May, I was asked during Q&A what my reaction was to the interface order. My reply was visceral. This seemed to catch some of my colleagues from the department by surprise. Based on the testimony we heard today, the order in question seems to be intended by the department to be benign instruction to the field on how to facilitate board interaction with sites and contractors. I don't feel it's that benign. I didn't feel it when I read it, and I certainly didn't get confidence in that with the answers that I heard today. To begin with, any interface document dealing with the rules of the road regarding R2 organizations should at the very least involve R2 organizations. We are but a small technical organization with a few dozen technical staff members, and the Defense Nuclear Complex has tens of thousands of workers. I don't know why we strike fear into the heart of the department, and I don't understand why they consider us to be onerous. If it were up to me, I'd double our staff and still find us inadequate. I also find it curious that the department wants to prevent access to pre-decisional documents. While I understand that they have an interest in making sure that such documents do not go public, we are obliged to obey the markings that the department puts on those documents. Even the weekly information that comes from our resident inspectors is vetted by the department to avoid information becoming public before its time. Congress instructed the department and the board to interact sooner in design and construction efforts to avoid us from weighing in after the fact. The same should be true of orders and regulations that deal with safety. Asking for somebody's opinion after a decision has been made, by definition, leads to an uninformed decision. Finally, in my career, which began at the Department of Energy, I always heard the words, mission first, people are always, regardless of the administration. And I believe that that is a core value and principle of the department. And yet, here we are with the department defining for the board that public health and safety and our consideration in determining adequate protection includes only individuals located beyond the site boundary of DOE sites with DOE defense nuclear facilities. At Savannah River, an office worker who didn't sign up for hazardous work duty but works in the range of the tritium facility. At Los Alamos, a worker building war reserve pits to preserve our deterrent. At Pantex, perhaps 3 generations of great Americans all working at the plant. They are not our concern, according to this document. Yet they are the mothers, the brothers, the breadwinners, and the soccer coaches in the communities of Aiken, Los Alamos, and Amarillo. They are the public. I know our staff will continue to identify safety concerns that could impact workers at the site, so-called co-located workers within the boundaries of the site, and the general public. And I know that the board will keep communicating. I hope that the department will continue listening and responding appropriately. Thank you.
Thank you, Ms. Connery. I will now offer my own personal closing remarks, and I will borrow from Ms. Connery's comment that that this order has in fact united the board. We've covered a lot of material today, but to me the primary question is DOE Order 140.1 consistent with the Atomic Energy Act? In my view, it is not, for many obvious reasons. Among them, the order claims to exempt DNFSB oversight from hazard category 3 and radiological facilities. But hazard categories aren't a DOE construct, nowhere articulated in the Atomic Energy Act. The order claims to limit the adequate protection of the public health and safety to people beyond the site boundary of a defense nuclear facility, thereby excluding workers' safety from the board's oversight. This cutout is nowhere articulated in the Atomic Energy Act. The order claims to exempt the board's oversight in situations where the Department of Energy determines that the adequate protection of the public health and safety is not adversely affected, thereby making the Secretary of Energy the arbiter, a specious and circular argument given that the Atomic Energy Act directs the board to opine and offer recommendations on that very question. Beyond this, a curious pair of secondary questions for me is where this overreach originated and whether the senior political leaders of the department were made fully aware of what the order attempts to claim. I have little insight on the department's internal activities which resulted in this order, but I do know these facts. Solid evidence exists that this order has been simmering inside the department for over a decade, spanning 3 different presidential administrations. I know that the order was pushed through without formal comments from the board and with only a single informal input in a cautionary email provided to me by the administrator of the NNSA just 1 week before it was approved. And I know that the administrator had not been on the job 3 months when all of this happened. For me, this set of facts is enough to postulate that the Department of Energy, the DOE Order 140.1, is a product detached from any agenda of the current or any previous presidential administration. Rather, it was a long-term initiative of the professional DOE staff who jumped on this opportunity to get it approved. All that said, the responsibility for its approval lies with the department's senior political leadership, and it is they who must now deal with the concerns and questions that have been discussed today. This concludes my personal closing remarks. I would now like to again thank the witnesses and the organizations and speakers today for supporting this hearing. I also want to thank all those who attended, either in person or via the internet. Our goal for this hearing was to gather information on the objectives of DOE Order 140.1, interface with the Defense Nuclear Facilities Safety Board, the board's access to information, facilities, and personnel, and the potential impacts to the board's resident inspector program. This was the first in a series of up to 3 hearings regarding 140.1. The next hearing will be at a date to be determined later by the board. This morning we heard testimony from the Deputy Secretary of Energy, the Associate Undersecretary for Environmental Health, Safety, and Security, and the Chief of Staff and Associated Principal Deputy Administrator for NNSA, as well as public comments. Thank you again for making those comments. We appreciate it. The board will consider the information gathered this morning to inform any actions that we may take regarding these issues. Once again, I thank everyone for participation at this hearing. The record of this proceeding will remain open until September 28th. This concludes the public hearing of the Defense Nuclear Facilities Safety Board. We are adjourned.